O tēnā tātou. Tēnā koe tū. Kua takato ia he arateka mō tātou I tēnei ata. Tautoko hau nā mihi kua mihia. Me mihi ki te kaupapa whakahirehira I whakahuhui ai tātou, te timatanga o te wāhanga o muri o te ruku tātari a mana wahine. Tēnā koutou katoa. Ko kai whakawā Reeves ahau. Ko tēnei te paiwhiri kei konei. Ko tākuta Hond. Ko tākuta Anderson. Raua ko Kim Narimu. Kāria Linda I konei. Ka uru atu ia ki runga Ipurangi. Kia ora Linda. Mai I Ahitereiria. Ka hui anō nei ki te rārangi take. Ko te mea tuatahi nā taia tinana. We're going to take appearances. And I have an RSVP list here. But I think given the significance of the moment, rather than calling roll, as has been my habit in the past, I will ask each group of council on behalf of their claimants to enter their appearance in the order that I have on the sheet. So, tuatahi ake for Kahui Legal for claimants Y81. Tēnā koe, Ms. Coates.
Tēnā koe, ma'am. O tira kia koutou katoa. Ko Ms. Coates ahau, ko Ms. Hauraki, Ms. Mora, Ms. Hauraki hoki. E whakakanohi ana I ngā kreme wai toru waru tahi, rua rua ono kore. So we appear as one of the team working on the Y381 claim, and in particular, we've been working with Professor Paparangi Reid and Ripeka Evans, who are both here and will be giving evidence across the course of the week. Tēnā koe.
Tēnā koutou. And I now call on Dixon and Co. Ms. Chestnut, Ma.
Mātua ake ka tautoko ahau I ngā mihi kua whāriki hia. I te pā whakawairua, ngau I whakatū te arawhata mai ia papa ki a rangi, nā reira me mihi ka tika. I te kai whakawā me ngā memo o te rōpū whakamana I te tiriti, ki ngā rau awa, ki ngā maunga whakahi, ka mihi, ka mihi, ka mihi. Ki oku kuia, ki oku marekura, ki a koutou katoa, e whakarau ka mai nei I raro I te maru o te tumuhiringa waka, tēnā tātou katoa. Ka moe a mahinarangi I a tūrongo, ka puta mai ko Raukawa tēnei e mihi atu nei. Ko Ms. Chestnut tōku ingoa, ka tū mātou ko Ms. Arapere, ko Ms. Castle, e whakakanohi ana I te rōpū Wāhine Māori tōku I te ora. Nō reira, tēnā tātou katoa. May it please the Tribunal, Ms Chestnut, Ms Castle and Ms Arapere for the Māori Women's Welfare League for Y381. Ms Arapere is overseas and is joining us via AVL link this morning. Good Wi-Fi permitting, Ms Arapere will be leading the evidence of Dr Aroha Harris on Thursday and Friday. Tēnā tātou.
Tēnā koutou, and kei konei Ms Arapere. Ms Sykes.
Te here ngā waka tēnā koe, te here ngā waka tēnā tātou, e te pai whiriwhiri e noho nei, tēnā rā koutou. Koutou ngā toki wahine me tō pūru taitama e noho takitahi nei, tēnei rā. He konei tahi māua ko Ms Sykes, e tū ana i roto i o māua whakapapa wahine i tēnei rā, nō reira ko mākino ko muri whenua tēnei e tū atu nei. Ka whakakanohi māua i ngā kreme maha i roto i tēnei ruku tātari, ko ngā nama o era kreme, ko wai tahi waru waru rima, wai rua whā iwa whā, wai rua whitu tahi toru, wai toru rima whā, wai tahi rua rima, wai rua waru whitu whā, wai rima rima waru, wai rua whitu rua waru, wai rua iwa toru toru, me wai rua waru whitu rua. Engari, ko te kaupapa matua o te rā, ko te kawe i ngā kōrero a te kreme wai toru waru tahi, ko māua ngā māngai roia mo whaia tōna awa tere huata, ka tai mai akua nei. Nā runga i tērā, kia tauranga manaakitanga hine tīwei ki runga i a tātou katoa. Tēnā koutou.
Tāmiki Legal.
E te kai whakawa, tēnā koe, kei te mihi hoki ki ngā mema o te Raipunara o Waitangi, tēnā koutou katoa, e te ropu o ngā roia, koutou ngā kaikirimi, huri noia ki te whare, tēnā koutou, tēnā koutou, tēnā koutou katoa. May it please the Tribunal, ko Ms Rautana Ho, kei konei raua ko Mr Ye, mō ngā kaikirimi, kei te kamupeni o Tāmaki Legal e mahi ana. We are appearing this week on behalf of Y762, Te Uhu Urunga Aroha Evelyn Kiriopa, the Kiriopa whānau, and members of Te Ihi Ngārangi, Merle Ormsby, Daniel Ormsby, and Manu Patina, for and on behalf of the late Te Aho, Mary Pilo, and members of Ngāti Tamakopiri and Ngāti Hotu, Y1196, Esme Wairati Sherwin, the late Emma Gibbs Smith, and her whānau as members of Ngā whānau o Waitangi Horututu me Tā Putaputa o Pahi, Ngāti Kawa, Ngāti Rahiri, and Ngāti Raumati, Y1477, Catherine Nicol and Sonia Matheson on behalf of the late Catherine Nahuia Marden, Y1477, Te Inga Harris and Lee Harris, and the Harris whānau Y1531, Robert Gable and Dr. Kirsten Gable and the Ngāti Tara Hapu Y1886, Tessa Reihana and her whānau and members of Ngāti Tautahi Kiringa, Y1957, Reuben Porter on behalf of the descendants of Mate Rangatira, Lily Tuwairua Porter and Heri Peti Poata and members of Whānau Pani Y1968, Denise Egan and her whānau Y2005, Jasmine Cotter Williams and her whānau Y2063, April Grace, the late Charlene Walker Grace and their whānau Y2206, Violet Nathan and Maringi Te Araha Kaiva Emily Pia Broughton on behalf of themselves and their whānau Y2217, Bryce Peter Aldridge, Russell Owen Smith and Stephen Mark Renata on behalf of the late Nuki Aldridge and the Wāhine of Ngāti Pākehī, Y2377. Violet Walker on behalf of herself, the late Nuki Aldridge, and members and descendants of Te Tahawai and Ngāti Uru, Y2382. Susan Taylor and the Wāhine of the Taylor whānau, Y2729. Annette Hale and Tumo Wikatu on behalf of the late James Torpy, Kokiri Wikatu and the Wikatu whānau, Y2743. Violet Walker as a member of Ngāti Kahu, Ngāti Rangi, Ngāti Parau and Ngāpui, Y2818. Michael Williams and Jessica Williams and their whānau and the Wāhine of Ngāti Pango, Y2838, and Okurua Rogers on behalf of her whānau and Ngāti Kohiriki, Y2869. Tēnei te mihi, kia koutou katoa.
Tēnā kōrua. Māni Hona. Tēnā koe te kaiwhakawā o te rei te ropu whakamana i te tariti o Waitangi tēnā koutou. Tuatahi, tautoko mārika i ngā kōrero i puta i tēnei ata. Tuarua, i te kaiwhakawā, he kaupapa nui tēnei i tēnei wiki mō ngā wāhine Māori katoa. Nā reira, me mihi aroha ki ngā wāhine Māori kai kirimi kua riro i tēnei kaupapa. Ara ko Tāhua Murray, rawa ko Margaret Love Mā. Nā reira e mihi mareikora moe mai rā. Toa toru tēnei te mihi atu ki te marae o te hiringa waka, o tērā koutou katoa kua tae mai ki te tautoko e tēnei kaupapa whakahirahira. A tīnana mai me ngā tangata e runga i te ipurangi, tēnā koutou katoa. Ko Style Toliafoa toku ingoa, ko Rock Soriano toku rangatira, nei maua mai i te tari o Māni Hona Lawyers, he whakakānohi maua mō ngā kirimi e ono, wai 58, wai 972, wai 1,612, wai 2,389, wai 2,945, wai 2,997. Mauri ore te whare, tēnā koutou, tēnā koutou, tēnā koutou katoa. Tēnā kōrua. Bryce Lyle.
Tēnā koe te kaiwhakawā, anō hoki kia koutou ngā mema o te rōpū whakamana i te tiriti o Waitangi, tēnā koutou. Ko Ms Swedland ahau, ko Ms Sreen tēnei, katu nei moa mō Y2655, a claim on behalf of Ngā Kairohi Nannies Against P. Y237, a claim on behalf of Mua Upoko and the Taueke whānau. Y914, a claim on behalf of Waimatu Taimai. And Y2676, a claim by Maurice Lant on behalf of Tairāwhiti Wāhine. Tēnā koutou.
Tēnā kōrua. Kaupari Law.
Tēnā e te kaiwhakawā o tira e te pai whiriwhiri e tuku ana i ngā mihi kia koutou e noho nei ki te tēpū ki te whakarongo ki ngā kōrero a ngā mana wahine ka tū ki mua i a koutou. O tira e mihi ana ki ngā āhuatanga kua tai tātou ki tēnei rā. E tika ana ka ārahi nei ngā kaikireme ngā mana wahine kua tai mai no te kreme wai toru waritahi ki mua i a koutou ki te arahi tēnei ruku tātari. E mihi ana ki te kaupapa, i ki nei koe te mananui o tēnei kaupapa. Ko māwatahi e tū nei, e tū whakahihi, e tū whakaiti nei, ki te nui o te mana kei roto i tēnei ruma. Ki te nui o te mana e noho nei, e hīkaka ana ki te whakarongo ki ngā kōrero i tēnei wiki. Ko ahau ko Ms Hiruini e te kaiwhakawā ko ki takutaha ko Miss Evans no te tari o kaupare law. E whakakanohi ana i ngā kreme e rua ko wai. Rua whetu tahi whetu tērā he kreme nā Jade kake. Me te tahi kreme anō hoki wai toru kore toru he kreme nā Nora Rameka rātau ko Rukuwai Allen ko Henny Brown anō hoki. Ka te mihi ana ki te whare tēnā koutou.
Tēnā kōrua, Woodward Law.
Good morning, Tribunal. The New Zealand Maori Council is here today to support the opening. Donna Hall, and with me is the newest member of our team, Ms. Hilary Royd, who will be present for the week. And on AVL, we have Ms. Darshni Dawn, who will also be in person. There are a number of claimants supporting the Council's case. We'll put in a memorandum so we don't stop proceedings. Thank you.
Tēnā koe, Ms. Hall, tēnā kōrua. Oranganui Legal.
Tēnā koe te kaiwhakawā, may it please the Tribunal. Council's name is Rongo, and I'm here on behalf of 4 claims. Y2188 on behalf of the Kānahi Umutahi Hapu of Ngā Ruahine. Y2236, a claim on behalf of Irina Clark and her whānau. Y2709, a claim for Rosario Hotere and her whānau. And Y3159 for Ngaitai. Mum, at this moment I'd just like to acknowledge the attendance also of 2 of my daughters. Amelia was 2 months old when she attended her first tribunal hearing, and 3 months old when she got kicked out of her first tribunal hearing. Hopefully she won't get kicked out this week. But we thought it was important that they attend here this auspicious occasion and learn more from the Wāhine of Mana that are speaking today. Kia ora, Mum.
Tēnā koe. Te Ārahi Law.
Tēnā koe e te kaiwhakawā, tēnā koutou te ropu whakamana i te tiriti o Waitangi. Council's name is Ms. Veikosa from Te Arahi Law, and I appear on behalf of several claims this week. The Kapiti Island and the Whitirea block claims, Y88 and Y89, a claim by Stephanie Turner and Henny Collins, Y113C, the Ngāti Kauwhata ki te Tonga settlement process claim, Y1729, the whānau and hapu of Te Tai Tokerau settlement issues nehua claim, Y1837, Te whānau Apanui Manawahine Sterling claim, Y2257, the descendants of Te Hirawana Karaitiana claim, Y1928, the Raketapuna descendants of Ropoama Pohe claim, Y1632, and the Public Works Act and Rating Act Greenaway claim, Y2570. I also want to acknowledge one of our claimants who is present here today, Whaiaani Parata, with her daughter-in-law Carmen Temu Parata, ngā mihi kia korua. More of our claimants also, Your Honour, Stephanie Turner and Whaia Henny Collins will be attending throughout this week. Tēnā koe, Judge.
Tēnā koutou. Te Mata Law.
Tēnā e te kaiwhakawā. Tēnā koutou te ropu whakamana i te tiriti o Waitangi. Ko Miss Joy Tokawangoa no te tari o Te Mata Law. I appear on behalf of Y3018, Y1823, Y2219, Y2673, Y2816, Y2823, Y2824, Y2830, Y2837, Y475, Y2072, and Y2819. Tēnā koe.
Tēnā koe, Ms. Joy. Phoenix Law.
Tuatahi nei rā ngā mihi ki te marae atu nei a te herenga. Tēnā koe e te kaiwhakamua. Me hoki koutou te rōpū whakamana i te siriti. Ko Ms. Wipiri tēnei, ko Mr. Thompson tēnei, ko kei konei māua, ana i te tāri o Phoenix o ki raro i te maru o Miss Mason. E te kai whakawā toru te kau mā rima wā mātou nei kaikirime ki tēnei pakirehua. Wai rua waru whā toru, wai rua iwa rua whā, wai rua iwa waru waru, wai rua waru rima kore, wai rua iwa kore, wai tahi whā rua whitu, wai tahi iwa whā kore, wai rua iwa toru, wai rua iwa whā, wai rua iwa rima, wai tahi ono whitu toru, wai tahi rima whā tahi, wai tahi rima iwa tahi whitu, wai toru kore tahi kore, wai rua waru whā whitu, wai toru kore tahi rua, wai rua waru whā ono, wai toru kore kore kore, wai rua waru whitu toru, wai rua iwa, wai rua iwa waru, wai rua tahi waru, wai rua iwa rua toru, wai toru kore kore tahi, wai rua waru whitu rima, wai toru rua iwa tahi, wai tahi rua kore, wai toru whitu waru, wai toru rua kore, wai rua iwa rua, wai toru tahi kore rua, wai tahi rima kore whā, wai rua mō taku he, wai toru rua waru iwa, wai toru tahi kore tahi, wai rua iwa toru tahi, wai toru iwa mō taku he, rua iwa toru tahi. Nei ranga mihi ki tētahi o ngā kaikirime i haro mai ki tēnei kaupapa a Jane Ruka, tēnā koe e te rangatira mō tō haere mai ki konei. O tira, tēnā koutou katoa.
Ka tēnā koutou. O tira, te nahu legal. I think we got somebody online.
Ai, ka tae koe te rongo i ahau?
Ai.
Tēnā koe te kaiwhakawa o tira te rōpū whakamana i te tiriti o Waitangi. Ko Mrs. Mātenga ahau e whakakānohi ana i te i ngā kai kireme wai tahi iwa whāwhā, ngā hapu o kereru. Ka tae mai ahau a pōpō ki ki here ngā waka marae, ka tae hoki Mr. Tenahu hei te rāpare. Tēnā koe te kai whakawā.
Tēnā koe, Ms. Mātenga. Waikro Panoho.
Tēnā i te kai whakawā o tira tēnā koutou katoa. Council's name is Ms. Walker of Waikro Panoho and Associates, appearing today on behalf of Y1781, a claim by Tracy Hillier and the late Rita Wordsworth on behalf of Ngāi Tamahaua Hapu. Tēnā koe.
Tēnā koe. Ara moana law. Ms. Thornton.
Tēnā koe, Mum. Ko Linda Thornton ahau. I'm here this morning on behalf of Vivian Toeki, Y1629. I am asking Mom if I could be given leave to attend for the remainder of the week on the AVL stream. I have no questions for anyone.
Yes, I'm happy to grant that leave, Ms. Thornton.
Thank you, Mom.
Whenua law. Mr. Whenua.
Tēnā koe te kai whakawā. O tira tō pairanga tira whiriwhiri nei, tō tātou kaupapa tēnā koutou. Ki tō tātou tūnane i whakatūwhira, tō tātou hui tēnei ata i roto i te tika me te pono kai te mihi atu au. Kia koe, he mihi anō hoki ki tērā whare no tātou katoa o te here na waka, e hia nei tātou nā hunga tauira kua noho i raro i te maru o taua wharera whakakā nei nā hine naro te marama anō hoki nā reira ki te whare atu rā tēnā koe. Kia koutou aku hoa roia kua ingoa anō hoki nā wahine whai mana i whakatō atu i tēnei kaupapa i mui a tātou tēnā koutou. Ko taku ingoa ko te whenua, anei ahau, a heiroia mō nā kreme e toru nei, ara ko wai rua waru rima iwa, koera te kreme o te runanga o nā kaimahi o Aotearoa, CTU, ko wai rua waru ono whā, te kreme o te runanga o nā toa āwhina, New Zealand Public Service Association, me te kreme anō hoki o wai tahi rima tahi, te kreme o te hapu o nai tamate ki wai o tahe. Anei ahau e noho marungi te purangi o te roa ake o tēnei rā, e runga i taku kaupapa anō i tāmaki te ahiahi nei, ka rere atu ki te hirina waka, i runga i te nui o te kaupapa, te tai a tinana, pōpō engari, ma'am, I'm seeking leave to appear via the AVL for the majority of the week and in person, pōpō due to commitments i te pō nei i tāmaki. I don't have, I'm observing this week.
I'm happy to grant that leave, Mr. Whenua.
Ina koe.
And Awhiaki Chambers.
Tēnā koe te kai whakua. Ko Reka Aria Ahau, appearing on behalf of Awhiaki Chambers, and we are representing two claims, Your Honour. Claim Y2278, and which is Tracy Waitokia, and another claim is Y700, Dallas King, on behalf of the committee Maori o Whirinaki for Tihikutu Hapu. And Your Honour, I would also like to seek your leave to attend via AVL, as I'm more on the observance side this week. Tēnā koe, ma'am.
Okay, that leave is granted, thank you. The Crown.
Kia ora e te kaiwhakawa, noku te he ki aku hoa te krauna. Kei konei a Miss Cherrington no te tari o tūkau law.
Oh, okay.
Ai, wari hau pia ki te tuku aku RSVP. Noku te he.
Auwe.
Auwe, kei te tika. Engari, e tautoko ana hau ngā mihi kua mihia. Kia koe te kai karakia, nāu I whakapuare tō tātou nei hui I tēnei ata. Nei rā te mihi kia koe, kia koutou ngā kai kreme, e hāpai ana, e kawe ana tēnei kaupapa, whakahirahira a tātou, nei rā te mihi kia koutou hoki. Ai, I te kai whakua ko Miss Cherrington tōku ingoa no te tari o tūkau law. Hei whakakānohi ngā kreme e rua ko Y682, te runanga o Ngāti Hine, ko Y14641546, te kapotai. And Your Honour, I'm here in person today and tomorrow and seek leave to attend via the AVL on Thursday and Friday.
Okay, that leave is granted. Thank you, Ms. Cherrington.
E mihi ana, noku te.
Te Corona.
E te ropu whakamana I te tiriti, I te kai whakawā, I ngā roia, I ngā kai kareme, ki tēnei wharea tāhua. Tēnā koutou katoa. He mihi hoki ki te kaupapa o tēnei wiki whakahirahira, me aro ki te hā o hine ahu one, kei te mihi. Kātū mātou mō te korona I tēnei mea, ko Ms. Dean tēnei, ki toku taha māui, ko Ms. Maria Delianis and Ms. Emma Sidman. Tēnā koe.
Tēnā koutou. Thank you, everybody, for those appearances. And We are still running slightly ahead of time, which I think is a first. But let's carry on. Everyone will have received the timetable for the week, which sets out the mahi ahead of us for this week. Now, before I invite the Crown to begin with their opening statement, are there any matters that Council wish to raise before we get going this morning?
Kei te mihi atu kia tātou. Ma'am, the Crown is expecting some reply to questions of clarification. The questions are quite challenging, I think, and require better reflection than the few days that we've had to consider them. And I would ask for an extension for 1 month for those questions of clarification to be answered in writing for and on behalf of those witnesses that are presenting this week.
I think we'll just let that sit for the week and just see where we are at the end of the week. But certainly, in principle, I wouldn't be averse to that. But we can see where we are as the week progresses. Only one matter that I wanted to raise, and that is, as with most hearings, Dr. Tuhiwai Linda Smith has given me a list of relationships that she has with various lawyers and claimants and so on and so forth on the basis that some of those could possibly be viewed as conflicts. My response to that is, well, her knowledge and experience in this area, of course, is the reason why she was asked to participate in this panel. So, I'm happy to expand further upon that, but really, I think we have come this far with those relationships being in place without them being challenged in any substantive way. I think probably my inclination is just to carry on, but I guess for the record, for the Crown's benefit, and for anyone else who may be interested in that, she's declared whakapapa relationships, family relationships with, I think, with Ms. Coates. Who else? Yeah, previous working relationships with, numbers of people in terms of academic endeavours that she's undertaken over the years. I can provide further details of that if you want that later in the week. Sorry, the details just escape me. But I think the key thing for you to understand is I'm not concerned about it, but if that does raise a concern for you, you can raise it with me by the end of the week. Yep. All right. So if there's no further matters that Council wishes to raise at this point, I will invite, as per the timetable, I will invite the Crown to make their opening statement, please.
E te ropu whakamana I te tiriti. Tēnā koutou anō. The Crown acknowledges the claimants in the Mana Wāhine inquiry. the witnesses who gave evidence in the tuapapa phase of hearings, and the witnesses who are to present evidence this hearing week and in this new phase of inquiry. The purpose of this opening statement is to outline the Crown's observations and approach to this new phase of inquiry. This statement addresses the inquiry as a whole, though with a focus on the issues highlighted for this hearing week. The Crown particularly wished to make a short opening statement during this hearing week because this new phase of the inquiry will be one where the Crown will participate more actively than it has before. And because due to the timetabling of this hearing, preparation of cross-examination wasn't possible. I'll be speaking to the opening statement filed on Friday, but we'll make a number of interpolations. And I will be, as indicated, brief. This opening should be considered alongside the Crown's initial statement of response, which was filed on the 19th of May. The Crown in particular hopes that the broad acknowledgements made in that response might assist the Tribunal in focusing the issues for inquiry and in greater focus going forward. Turning firstly to those acknowledgements. The Crown has acknowledged that acts and omissions of the Crown contributed to the erosion of traditional tribal structures, including traditional systems of authority, economic capacity, and the physical, cultural, and spiritual well-being of iwi. Every tribunal district inquiry examines these aspects, and every historical settlement deed negotiated with iwi and hapu rehearse these concepts. These acknowledgements necessarily mean that the Crown accepts the traditional role and status of Wāhine Māori was disrupted by colonisation and past breaches of the treaty. The introduction of Christianity and Western political and constitutional structures as features of colonisation have had a profound impact on Māori, including Wāhine Māori. For Wāhine Māori, this profound impact would have been distinctive, given the historical roles of women in both the church and in political and economic life. The Crown has acknowledged that colonisation and past breaches of the treaty and the ongoing effect of historical injustices on iwi, hapu, and whānau are likely contributing factors to Wāhine Māori experiencing disparities in wellbeing, representation, and outcomes. The Crown acknowledges too that Wāhine Māori are associated with statistics which are in some cases worse than for the general Māori population, for example, incarceration statistics. It's also relevant and important to acknowledge that challenges to the traditional tribal society have come from broad global trends and fluctuations, including capitalism, urbanisation, industrialisation, democratic political structures and principles, and feminism. To explain further, the global trends and fluctuations referred to here are the major global forces that have had significant impact on most, if not all, societies across the world in the time between the early 19th century and the early 21st century. It's undoubted, for example, that feminism and the advancement of women's rights and status have impacted the structures of many societies and the roles of women in them. This inquiry has both historical and contemporary aspects, and I'll make some brief comments on the historical aspects first. The role and status of Wāhine Māori was the focus of the 6 tuapapa hearing weeks, and is a focus of the evidence that will be presented this week too. The opening submissions of the Y381 claimants describe a pre-colonial society based on whakapapa, which is necessarily non-hierarchical and where men and women live in relational balance. The opening also says it is important to not romanticise pre-colonial society. That is a sensible caution, and the Crown agrees is important for the tribunal inquiry and reporting. Here I would note that the Crown does not intend to test forensically or to produce separate research reports on the topics stressed during the tuapapa phase. The Crown asks that the tribunal take care in how it incorporates that material into the historical narrative it includes in its reporting, noting the topics covered in that phase are nuanced and oversimplification must be avoided. The Crown has, as I've mentioned, acknowledged the impact of past treaty breaches on Wāhine Māori, including as part of a disruption of traditional tribal ways of being, and as a likely contributing factor to disparities experienced by Wāhine Māori today. The scope of this inquiry is broad and should focus this new hearing phase on the many aspects of the inquiry that relate to contemporary issues which are relevant to many current Crown work programs. I'll now make some brief comments on the contemporary aspects of the claim. Consideration of the contemporary aspects of the claim will involve, as is usual, where the tribunal is considering whether to make breach findings, considering also what recommendations it might also consider. This is all to come, but I would note assistance might be gleaned from bearing in mind throughout the inquiry that remedies sought in the opening submissions of the Y381 claimants. For example, the opening submissions seek enduring constitutional transformation, a partnership between the Crown and Wāhine Māori, devolution of Crown roles to Māori organisations accountable to Wāhine Māori, and associated shifts in Crown funding. The detail of those proposals will need to be tested by the tribunal, as is usual. For example, what is intended by enduring constitutional transformation? And how is this enduring constitutional transformation anticipated to recognise and uphold the rangatiratanga of Wāhine Māori? How the remedies sought relate to Crown approaches to working with iwi and Māori in particular contexts. For example, in the treaty settlement context, are claimants asking the Crown to impose more prescription on the iwi and Māori groups it negotiates with? How should the autonomy of iwi, including in respect of determining tikanga or kawa, be balanced against increased Crown intervention or prescription? These proposals, these remedies sought, of course, also highlight the complexity of how the tribunal will need to link this inquiry to the range of other kaupapa inquiries on foot. These include the constitutional inquiry, the health inquiry, the education inquiry. All participants in this inquiry, including the tribunal, will be mindful of the risks and costs of unnecessary duplication and the need for consistency and consideration of these issues across different tribunal panels. This is not to suggest that overlapping matters must be dealt with elsewhere. That's not our submission. Just that there needs to be a clear description and clear delineation of the issues that are for this inquiry and how that is different or distinct from the issues that are being considered in the other kaupapa inquiries. Turning now briefly to the topic of the 1993 appointments to the Treaty of Waitangi Fisheries Commission. And firstly, it's only right to acknowledge Dame Mira Sazi and her role. Kia ora. From the opening submissions of the Y381 claimants and exchanges at the April Judicial Conference, it's evident that claimants see the appointments in 1993 as an important issue for further inquiry. The fact that Dame Mira was not appointed in 1993 is considered, despite the appointment of two other Wāhine Māori at that time, to be emblematic of the explicit exclusion and marginalisation of powerful and qualified Wāhine Māori from positions of influence and key governance roles, to quote their opening submissions. The tribunal has previously indicated that following this hearing, it will reflect on the way this hearing functions to assess how to proceed, particularly in the context of a deliberately inquisitorial and targeted approach, and how that will include how the tribunal wishes to approach particular issues or topics. On this topic, it might mean what aspects of the issues related to fisheries warrant further specific focus, whether that is the particular appointments process followed in 1993, the role of Wāhine in the fisheries settlements more generally, the Crown's current approach to such appointments. Acknowledging this event as the genesis of the Y381 claim, the Crown considers its approach to appointments now and information and data held relating to that to be more significant for this contemporary kaupapa inquiry. If the Tribunal considered detailed exploration of the appointments process followed in the lead to the 1993 appointments is warranted, then the Crown will continue searching its records for what material it holds, and claimants can provide any further information further relevant information they may hold. I would note the fishery settlements and the appointments processes, I probably don't need to say this here, have a rich history. There were multiple tribunal inquiries that occurred, including one directly into the appointments process while it was underway. Accessing records and gaining an understanding of events may not necessarily be straightforward. I will last touch on the overall design of the inquiry. The Tribunal has indicated it will reflect on the way this hearing goes to assess how to proceed, how to gain sufficient focus and structure subsequently. And all participants are mindful of the number of hearing weeks currently available or currently anticipated, and indications from the Tribunal, for example, that the rangatiratanga po might be reported on 2025, or hearings for that po might be 2025, as was mentioned in the April Judicial Conference. And a recent review of the Tribunal's strategic direction mentioned the inquiry as a whole may be completed by 2035. With those overall timeframes in mind, so 2025, 2035, the Crown expects that following this hearing, there will be a need to address a range of design issues and structure issues, including the sequencing of topics, the focal issues for hearing weeks, how this inquiry will link to the work of other kaupapa inquiries, whether the Tribunal might report and conclude its inquiry on particular topics or issues in a phased manner, and how Crown evidence and submissions will fit into the overall inquiry design. The Crown thanks the Tribunal for the opportunity to give this opening statement, and I'm happy to address any questions you might have.
Thank you, Ms. Dean. I don't have any questions at this point. It may be that we will have more discussion, as towards the end of the week. I'll just check if we have any questions on the panel. Thank you. Right, Council to make the opening, joint opening submissions for Y381.
Ko te whakaro kei te kātahi anō ka kiti a koe i te ahorangi Maria Barge. Ka mōhio au kei te noho koe kei raro i te kapua pauri i te wehenga o tō tau tātou nei mokopuna mai tēnei ao. Ka whakaro hia i te atanei i te wā e orana o whaia tātāua nei kuia e kia nei te koe o te hinangaro o ngā tipiki a whānui, hei whakaro hea me pēhea tutu āhuatanga o te mana o te Wāhine. Ka noho pauri ana i runga i te ate nā te me kore taia te mihi ki a koe ki tō whānau i tēnei wā i runga tau atu āhuatanga. Kei wainga nui i tēnei pikitia i mua i a tātou tō whaia a hepora. I tai mai a wairua mai ki te tautoko te kaupapa o te rānei. Ki tana taha, maha ngā wāhine tō te ao Māori ki te ahake, ki te wero kia ngai tātou, ki te wero ki te korona, ki te wero hoki i ngā kuare e noho i o rātou nei kāinga, pēhea te tūāhuatanga o te wahine Māori, i runga i ngā whakaaro o te paipai, i runga i ngā whakaaro o ngā tari kāwanatanga, i runga i ngā mahi marae, i runga i te whakaaro o te kāwanatanga hoki, i runga hoki i te ao mahi pūtea. Koina te tino kaupapa, ana kore au i rongo i te atanei i taua mamai, i taua ahara, i puta mai te timatanga i kia nei o te tainga mai o te Pākehā, ki te whakakorengia te mana o tō tātou nei, e kia nei te mina o papātua nuku, te tū o te wahine i runga o na ake ao. Ana Maria, kei te mihi atu i a koe, i runga i te whakaaro hohunu, tā tāua nei whakapapa i a tāua, i runga hoki i te mamai, a te whakamomoritanga, e wehe ai wetahi o ngā kōtiro i tēnei wā, ki te ahake maumau ki au nei, engari he whakaaro nui ki au e timata ai tēnei o ngā whakaaro. Koinei te whakaaro i puta ai i ngā kareme, te whakamomoritanga o te mana wahine, he hai pēnei ai. Aha ko te mana o tō tātou nei tū i te ao Māori. Ko tāku nei mihi tuarua kia tātou i te atanei. Kia mōhio mai koutou i te mana o ngā wahine e whai whakaaro ana. Ko Mira Sasi, te wahine tuatahi tai atu ki te whare wānanga te Pākehā, he mau tohu ai mō te ao. Koea hoki tētahi o ngā Miss New Zealands i taua wā, engari kei te mamai ahau, nā te mea i ngā kuaretanga o ngā chachi o taua wā, ko te whakaarea koea te tuarua e hara i te tuatahi i taua wā. Koina te kaikiritanga o taua wā. Kia noho pēhi ana te wahine Māori kei raro te mana o te wahine Pākehā. Pērā tonu kia tua iwa i taua wā. Kei te whai ia i te whakaaro o te Mrs. New Zealand, koinei tana hia. And ko te whakaaro aha ko te Wikitoria iwa, tua iwa i taua wā, ko heke iho tonu ia, i raro i te mana o te Pākehā, o te wahine Pākehā, he hai pēnei ai. Koinei te kaikiri o te ao taua, ko te whakaaro kia, kei te tūtonu taua tu āhuatanga i mua i a tātou i te atanei. I Wainganui te pikitia nei, wetahi o ngā tino roia tō i taua wā mō ngā mana o te wahine. Koia wetahi o ngā waka o ngā wahine roia, hei whai whakaaro, he pakangana mō te mana o te wahine, i runga i ngā kreme i puta i te ao, ko Kathy Utau. Ka maumahara au i aia, me te tuahine a Denise Henare, a Darlene, me Angela Armstrong, me Winnie Jardine, me Atarita Pōnanga, me Jolene Patuawa, me Gina Rudland, nā wahine toa katoa o taua wā hei māngai mō rātou nei whānau hapu iwi. I runga i te moke o te tū o te wahine kei Wainganui i te Turiata Pākehā. He hai pēnei ai kore taia rātou e tū i mia tātou i te atanei. Koina te kia nei te mate o te colonisation e uru atu i ngā roia, i runga i rātou nei pakanga, mō tō tātou nei whānau hapu iwi, mō tō tātou nei tiriti. Moi mai koutou mā wahine toa, mā reikura mā, i runga i te whakaaro aha ko te aha kei konei tonu wetahi o hoa, kei te whai whakaaro mō taua tuāhuatanga, e whai ana e tātou i taua wā. Ana ki te wahine toko oro i tēnei wā, i tai mai ārita, Druis, nā mārei kura o te ao i taua wā. Kei te noho moke koutou i o pai i tēnei wā. Kei te wehe te nuinga a te Māori, Anne Delamere wetahi, he tino wahine mai taua wā. Ko Media Simpson, te wahine koi, i te wero ia tātou mo te reo Māori, mo te kore take o ngā tāne ki te kōrero Māori, koi nei te wero o tērā o ngā whae o te motu. Ko Iwa, ana, titero ki te āhuatanga o rātou, te āhua o ngā wāhine. Nā wāhine katoa, e noho ana i o rātou nei hāpari, hei te aha, hei tū pakari ai te ao Māori i runga i o rātou nei tikanga, i o rātou nei ture, i o rātou nei kaua, ki te whakaora ai tō tātou nei ao Māori. Ana kei koinei taku mihi tua toru i te rānei. Ka huri atau ki te tēpū. Ko ro te wā e tāre ana tātou mo te hake. Ko te whakaro ke mo te pūtea o te kāwana, hei whai whakaro mo tēnei kaupapa. Kārau i whakai ngā kōrero i puta mai taua wahine rā. Ko e ngā whakaro, e hara. Ko ro te wā e tatiri ana tēnei kreme i tutuki ai i mui a tātou. Engari ko te whakaro ke, ko te mate pekotanga o te Pākehā, o te kāwanatanga e kore taia ki te tutuki i tēnei o ngā whakaro. Koinei taku a wanga hoki i tēnei wā. Pēhea te pūtea, hei whai whakaro, me whakaoti pai i enei o ngā kōrero i puta. Ko, kāre anō i au i tīmata e ka kōrero, engari. Kei te tūau hoki ki te tautoko i te tohuna, i whakatūwhera o tātou nei hui. I ngā whakaro hohunu i puta mai ngā hoa tāne, i wahora. E hara e noho kāpuana te ao. E hara mātou e noho i te ao pauri, ko te hiahia me puta ngā reo te wahine i te ao mārama, kia mohi o mai te katoa, te ronga o tātou iwi. Tainoa, mai tēnei wā ki te ahakea, mo te oranga o tō tātou nei whenua, moana, hau, me ngā tangata katoa, he noho ana kei raro i o rātou nei whenua rangatira nei Aotearoa. Ka huri au hoki i te tīmatanga o ngā kōrero o ngā whakaro i puta mai ngā roia. I ahu te ara uwhea o tahu ki Papa Atuanuku, ka puta kuhine ahuone. Ara ko tōna tamāhine a hine tītama. Te wahine atua o te pō, nā te tangi o tīrairaka, e raru ai te iratāne a Māui Pōtiki tinihanga. I hahi mai te mano o te wahine e te kūnenga mai o te tangata. I te whakauru i te kukune, i roto i te kōpū o te wahine, ka tipu haere tōna tinana ko tōna wairua. Ka rongo, ka whānau mai te tamaiti, ka tēnei mauri ora mai ki te whaiao ki te ao mārama, ka whakamana mai tōna ira tangata ki te ao hau. He tau pai te tau, he tau ngehe te tau, he tau no te wahine te tau, tihei mauri ora. Ka huri au ki tērā o ngā reo e nāia nei, ko te raru ke whakarāpopotinga na te reo Annette Sykes, kia mōhio mai katoa, nā whakaro i puta mai ngā roia. Engari, kia mōhio mai, e hara i tēnei tū, i te tū māma, he tū pakari, kia pakari ai te ao ki te aha, whakarongo i ngā tikanga Māori, kei reira te reanga hei whakamana anō tō tātou nei mana Māori, mana motuhake, mana wahine, mana tāne. Kia ora. For the tribunal's benefit, I'm going to start with a couple of comments that I want to respond to my friends, the Crown submission this morning. And I will be bouncing around a bit in our opening submissions, which is appellation number I think 3.3.3. There will be 3 speakers for the opening claimants. I'm the first one, and I will be taking us to about paragraph 46. But I will like to, as I say, look at parts of appellation 3.3.3a, which is the original claim which was filed. and then I want to look at particular sections of the Crown submission, which I think are a minimisation or a desire to avoid the fact of neo-colonisation, the patriarchy that still dominates within the Crown structures, and the failure of the Crown to continue to respect the status and dignity of Māori women, notwithstanding the tinkering that's been made in a number of developments since the claim was lodged. What is really clear is that this is not a claim about Māori feminism. It is about the right of Māori to exercise power in accordance with our values and our principles. And the power of women has to be an actively protected right, both in decision-making but also in the development co-design of appropriate social structures to ensure the well-being of our people as promised by Te Tiriti o Waitangi. I found the approach in the Crown submission minimalist, and while there was a number of concessions, those concessions, even in the oral submission today, seem to be fettered by some of the rhetoric that is unfortunately dominating many of the political statements emanating from Parliament at the moment, which do not honour Te Tiriti, which are about dishonourable kāwanatanga and are not about ensuring that the dignity of Māori women is actively protected and restored, but also given prominence in the way we run this country. I think in my Māori things, from the back of the marae to the front of the marae, from the halls of white power to the halls of international power, and to look at the theoretical domains that are actually undermining that exercise and protection and duty to have that power. In its submissions, it quite cleverly done, actually thanks us for contemplating at paragraph 12 that we shouldn't romanticise pre-colonial society, which of course comes from our submission, but our submission says, nor should we dishonour the pre-existing rights and interests that Māori women enjoyed and still enjoyed prior to the arrival of the colonisers. Those pre-existing rights were actively protected by Article 2, the preamble, and a number of relationships in the express document of Te Tiriti itself, but are embedded in our psyche as Māori, and should not be, as I say, forgotten in any current effort to understand the nature and scope of the claim. The other concern I had in specific terms, and I think I don't want to pinch other kōrero that's coming from me from other people, is the paragraph 16 suggestion that we're here to risk the duplication of outcomes that have already been foreseeably attended to through treaty settlements. I think the statistics themselves, as we analyse them over the next few hearings, will be testimony to the fact that there hasn't been the equality of participation of Māori women in decision-making, nor has there been the active protection of Māori women from the full thwart of dishonourable kāwanatanga. The Royal Commission into the Abuse and State Care, the theft of our children from their whānau and their mama continues to dominate as the realities of the social norms or the social evils that we have to actually find solutions for. And the Crown cannot, in my suggestion, try to minimise their participation in the objectives of those outcomes by any suggestion that this tribunal will be a duplication of other inquiries that have already found the Crown's behaviour undesirable, minimising and in breach of not only Te Tiriti but human rights laws both nationally and internationally. And my final concern is the suggestion that, and this is maybe myself overstating the matters, that we have the rangatiratanga pou reported in the 2025 calendar year, as was suggested, and the disconnection of that pou from the actual praxis of what rangatiratanga may mean, for example, in the context of the theft of children, of the denial of funding to the Māori Women's Welfare League, of the failure to ensure the participation of the Māori Women's Welfare League in decision-making processes, preferring instead quangos like the iwi chairs organisations, which do not of themselves guarantee participation of any women's voices in their advocacy. So if I can go back to the first document, I want to pay homage today to our original claimants that have come and are still here with us fighting hard for the claim. Dame Areta Kopu of Ngāti Kahu, Ngāti Konohi and Te Aitanga a Hauiti. I think she's really te arawa whānau. She actually lived and worked amongst us for many, many years. And for solo mothers that were unloved, Areta was a must-go-to together with the late Mrs. Hornfeck. She was the president of the Māori Women's Welfare League for herself and on behalf of Wāhine Māori generally for a number of years. But she set up the first family court counselling program in Rotorua, which assisted women who were battered women. And she also assisted for many of the gang girls that were suffering from rapes. And I'm talking serious rapes. Areta was there to ensure that we had victim support for them long before victim support was ever created. Dr. Hope Tupara of Ngāti Tā Manuhiri, Rongo Whakata, Ngāi Te Rangi, Te Roro and Ngāti Korokoro, o Te Roro, and Ngāti Manu on behalf of the Māori Women's Welfare League and Wāhine Māori represented by Bernadette Arepere and Dixon and Co lawyers. Hope was one of the first women that I ever had the privilege of seeing speak on a marae. She spoke several times in support of the late Dr. Moana Jackson. She has never been sat down, and she carries I think the effervescent mana of Wāhine in everything that she does. Long-time school teacher, long-time advocate, long-time supporting the rights and interests of women and girls in everything that she has done. Ripeka Evans of Ngāpuhi, Te Aupauri, Ngāti Kahu and Ngāti Porou, for herself and on behalf of Wāhine Māori represented by Natalie Coates and Kāhui Legal. Ripeka is one of the most astounding Māori women's activists ever. She was regarded as a daughter by the late Dame Mirasazi. She has held significant roles in the development or Māori economic development terms. She was one of the organisers of the first Hui Taumata, which was the Māori Economic Development Summit here in Wellington. She was a close confidant of the late Wira Gardner in that Māori Economic Development Unit and assisted him in the establishment of the Waitangi Tribunal. In recent years, she is now a director working for her peoples of Ngāpuhi, facilitating outcomes for commercial interests for her people. Dr. Mary Jane Paparangi Reid of Te Rarawa and Te Aupauri for herself and on behalf of Wāhine Māori represented by Natalie Coates and Kāhui Legal. Dr. Paparangi was one of the most astute minds when she worked with the late John Rangiho and a number of others. I see Donna Hall's in the room here in Te Pua o Te Atatu. She was also one of the originals in the establishment of a work done by Paul Mare, by Mason in the health field. She's the leading, I think, intellectual that challenges the social stratum and racism and structural inequalities in the health sector. And she has been an inspiration for the last 4 decades in creating a number of Māori doctors, which she has, I think, really devoted her life to for at least the last 20 years. And Donna Awatere Huata of Ngāti Pakoe, Ngāti Porou and Te Kapotai for herself and on behalf of Māori women, represented by myself. Donna is author of Māori Sovereignty. She was certainly the one that inspired the Māori sovereignty movement. She, like many of the others, is an activist. She's had her full weight of the law against her. She's had her confrontations with the law, found herself, I think, at the worst context of being held accountable, being imprisoned by the law, but used the opportunity to develop literacy programs for women in prison. Since that time, she has done significant matters for her people. She's the Māori Climate Commissioner, and thank goodness she left Kahungunu, now living in Rotorua. So those were the original, those are the present claimants, but I want to take us a moment. I would actually like a minute's silence for the original claimants. I want to mention them all because they are so deserving of mention. Dame Whina Cooper, Dame Mirasazi, Dr. Eri Hapati Murchie, Dame Georgina Kirby, Violet Poe, Dame June Mariu, Hine Pōtaka, Dame Aroha Rereti Crofts, being past presidents of the Māori Women's Welfare League, Lady Rose Henare, Katerina Hotorene, Tepara Mabel Waititi, and Kare Cooper Tate for themselves and on behalf of Ngāti Hine. And I think it's really important that you do not underestimate the role of Ngāti Hine and the support of Lady Rose she gave to Dame Mira when Mira was refused to be appointed onto the Treaty of Waitangi Commission, and the support that she knew she had to give for Te Tai Tokerau because Sir James Henare was not available himself, and he had been a long confidant of our whaia Mira. We want the world to acknowledge those claimants. It's been 33 years since they filed their claim, and they have waited patiently as priorities of the tribunal has always seemed to deprioritise the needs of Māori women for whatever reasons. We're so glad that in the last 5 years we've got a panel that's led by a very capable Māori woman that has actually brought it up to some prominence. But we are frightened in the current climate that it would also be deprioritised like so many other things when we have waited so patiently for it to be actually given life to. I see Donna Huata's just joined us. She wrote a song a long time ago when we were treaty activists, How long must we wait? She may sing it for us, but that's how I'm feeling. How long must we wait for the justice that was ours, promised by Te Tiriti or Waitangi, at Waitangi so long ago. The hearing of the claims within this inquiry represents a constitutional moment. It is one of profound significance. It is the first time the Waitangi Tribunal has been called to confront the Crown's breaches of Te Tiriti o Waitangi through the distinct and intersectional lens of Wāhine Māori, their experiences, their leadership and their rights. This inquiry is not only notable for its subjective matter, but also for its expansive scope. It spans both historic and contemporary Crown actions and is also a full systems inquiry that will require examining the whole apparatus of government. It considers the deep and systemic harm caused to Wāhine Māori, including their structural exclusion, marginalisation and silencing across every sphere of public life, from health to education, from justice to economic development, from media to the environmental needs of our taiao, from justice to economic development, and so much more. The kaupapa is not confined to any single policy or agency, but interrogates the Crown's entire constitutional, legal, and cultural posture, and its persistent failure to honour its obligations to Wāhine Māori across these spheres. Wāhine Māori have been consistently excluded from decision-making, denied visibility and subjected to institutions and policies that disregard their status, voices and rights. These harms are systemic and enduring, inseparable from the Crown's constitutional responsibilities under Te Tiriti. And this is really important because we are suffering at the moment from a dishonourable kāwanatanga who is extending its power reach beyond its legitimacy to undermine the very social fabric of which this country and this nation is built on by invisibilising the Tiriti and trying to deny the Te Tiriti legitimacy in the lives of Māori women. The claim also speaks to the deep and often unspoken harm caused by the Crown's role in the distortion and erosion of tikanga Māori. And I'd like to take the tribunal at this point to the original claim, if I can, and to the comment at paragraph 3.2 of that claim by the Minister of Māori Affairs, as he was, Doug Kidd, when he commented on the claim, saying, "Their problem was their culture and Māori men, not the minister. They, Māori women, need to stand on their hind legs." His statement was absolutely deplorable. His statement blamed the power dynamics of colonisation on Māori men who, like Māori women, have been at the bottom of statistics in the exercise of power and who have been actively denied. It is part of the rhetoric now that seeks to disestablish Manatu Wāhine, or the Ministry of Women's Development, because women are not actually equal to men in our society, and it is part of this tragic rhetoric which is denying Māori women and Pākehā women equal pay, equal rights, equal opportunity to ensure equality of outcome in the way that they are treated for their worth in this nation. Paragraph 9. The Mana Wāhine inquiry is therefore not only about recognition of past wrongs, but it is about reimagining how Te Tiriti is to be understood and applied in relation to Wāhine Māori today. This claim invites the tribunal to consider what it truly means to protect tino rangatiratanga in a way that restores balance, affirms tikanga Māori and gives Wāhine Māori the authority and space to thrive as leaders, as decision makers, as knowledge holders, as healers and protectors of our people and our lands within both the kāwanatanga and rangatiratanga spheres. As this is the first hearing in the Crown breach phase of the inquiry, the claimants see this as an important opportunity not only to speak to the rangatiratanga pou, but also to ensure that we set out the specific experiences and evidence underpinning this claim and assist the tribunal in its broader task of framing the inquiry. And I'm going to leave those matters for my friend Natalie Coates to take the tribunal through. I do want to look, though, to the background and context of the claim in my time that's left and look at some of the principles that I think are really important for us to grapple with. The first kōrero yumo, he tau, pai te tau, that was a speech given by Mirasazi in 1984 at the Tūranga Waiwai Hui, when Māori demanded then that we be 50% in all decision-making models. That was recorded at the hui at Tūranga Waiwai following the hikoi to Waitangi that had been organised by many of our claimants, Donna, Ripeka, myself, and people like Tuku Morgan, Hone Harawira, but also Robert Mahuta had been very much involved in that initiative. Mira has also inspired our second introduction, whakataki, of the background and context to the claim, when she said, "Kei roto i taku hinengaro, i roto i taku whatamanawa, e pēnei ana. Me te whai mana rāno o te wahine, ka tahi anō te iwi Māori kamaranga. It is my mind and soul. In my mind and soul, I believe that it is only when women achieve mana recognition that the Māori people will rise up." The catalyst for the Y381 claim was the Crown decision not to appoint Dame Mira as a permanent commissioner, having set up as an interim commissioner to the Treaty of Waitangi Fisheries Commission. You can't understand her failure to be appointed in 1992 without looking at the fact that she was one of the few Māori women, like myself, appointed in 1989 as part of the Māori Fisheries Act. She was one of the few Māori women at that time with a decision-making role in establishing the first part of the fisheries settlement, which was to ensure a transfer of quota after Muri Whenua had actually challenged the quota management system being introduced, firstly in the Waitangi Tribunal in Muri Whenua itself, and then in a decision in the High Court before Justice Griggs. MIRA was part of the continuum of that battle from the time that the introduction of the quota management system was first mooted, when the claims were being held of her people in Muri Whenua, right through to the interim injunction and relief that was provided by Justice Griggs, right through to the interim working parties that were established under the chairmanship of the late Sir John Wallace, and under the chairmanship of also the Honourable Richard Prebble at that stage, which invoked the treaty settlement around Māori fisheries. And the first part of that was to ensure that Māori would get 10% of the quota that was going to be introduced transferred, and that the Māori Fisheries Commission would be set up as an interim body to manage that. Mira was one of the Māori Fisheries Commissioners. She was there from the beginning, and she was the first and only woman that challenged some of the capitalist notions of the Fisheries Commission, and this is set out and will be the subject of evidence later this week by Dr. Carla Haukamu. She was a prominent Wāhine Māori leader who had served as national president of the League, held positions on numerous national boards, and possessed significant cultural, economic and governance experience. On the 8th of March 1990, Dame Mira was the sole Wāhine Commissioner appointed to the Māori Fisheries Commission under the Māori Fisheries Act. In a male-led governance landscape, Dame Mira is recorded as championing a Māori fisheries governance model in hapu autonomy, cultural revitalisation and self-determination, exposing the disjuncture between Māori aspirations for rangatiratanga and the Crown's prioritisation of regulatory containment and political palatability. When the Treaty of Waitangi Fisheries Claims Settlement gave legal effect to the terms of the Sea Lord's deal, it formally reconstituted the Māori Fisheries Commission. And can I say it was a big deal back then? Hui around the motu happened not only regionally but at marae, because this was the largest proposed treaty settlement of the time. And it was really important, and it was enumerated at many hui, that the next governance arrangement should have what we said at the hui in Tūranga Waiwai, 50% of those governance bodies should be Māori women. The Treaty of Waitangi Settlement 1992 introduced new qualifications to the earlier broad power of the Governor-General to appoint commissioners on the advice of the Minister. Section 16 required consultation with the Māori negotiators to the Sea Lord's deal, and with such persons who are, in the Minister's opinion, representatives of Māori. Again, Dr. Haukamu's evidence will cover this, but I just want to remind you, Muri Whenua was shafted in that process. The negotiator in that period was the late Honourable Maturata. He was not appointed either on the new Treaty of Waitangi Fisheries Commission. Mira was not appointed, but the emerging Crown agent, the Honourable Shane Jones, was. And it's not just the dispute between Muri Whenua, or as what the Honourable Mr. Kidd said, was to be something that we as women should deal with our men. There were deliberate strategies in place to deny mana wahine to be part of and equal to in the governance arrangements of the most important treaty settlement of that period. A letter dated 16th of October 1992 was sent by the Minister to 73 Māori organisations seeking nominations. The letter and rushed consultation period sparked the filing of a Waitangi Tribunal claim challenging the appointment process. The claimant, everyone will know her, was Hariata Gordon for her peoples of Ngāti Pāua. The tribunal inquired into and ultimately upheld the right of iwi to nominate their own representatives and recommended a national hui to determine criteria for appointment. The tribunal also found that the Māori negotiators to the Sea Lord deal, who had been appointed by the Crown, not iwi, should not have the power to nominate commissioners. And this is where it gets a bit grey, tribunal, and this is going to be a significant issue that I think you have to grapple with in unwinding the facts of what occurred. I don't propose to go into the hui. All I can tell you is that Mira was the darling of the Māori nation. She was loved everywhere. She was supported by the Māori Women's League, Welfare League, by her peoples of Muri Whenua, and because she had been so intimately involved in the Māori fisheries negotiations approach, she was seen as a leveller for those that were more capitalist in their objectives. Dame Mira was informed of her removal only hours before the formal announcement, and this is an issue that perhaps we should think about a warrant to call Sir, the Honourable Shane Jones to explain. Something that is certainly has been contemplated in my mind, because there were certainly discussions that took place with people at the higher echelons, and if the late Widow Gardner had been alive, he was going to give evidence about those discussions. Given Dame Mira's credentials, it is difficult to reconcile her non-appointment with any assessment based purely on qualification or experience. It was Dame Mira who gifted the name Te Ohu Kaimoana, later adopted by the successor organisation that exists today. It is the evidence of Dr. Haukamo that the name Te Ohu Kaimoana framed the Commission as a collective working group with responsibilities. Dame Mareta Kopu's evidence is that Mira was a powerhouse to be reckoned with. She was incredibly sharp, smart, could kōrero beautifully in either language or Māori, and was far more eloquent than many men. She was also beautiful, drop-dead gorgeous, walked into a room and everyone looked at her. My view, shared by many of us at the time, was that they saw Mira as a threat who had to be neutralised. The sudden and unexpected decision of the Minister of Māori Affairs to exclude Dame Mira led to the filing of this claim. It underscored the challenges faced by wahine Māori across Aotearoa in asserting rights and being appointed to positions of authority within Crown institutions. And I don't want to takahi the mana of the two other women that were appointed, but we had always sought for equal representation, and certainly not the appointment of other women at the expense of our accepted leadership. The explicit exclusion of Dame Mira is a central issue to this claim because it raises allegations of the systemic marginalisation of powerful and qualified Māori women from positions of influence in key governance roles. The whakatau ki he wahine me papa e orai te tangata through women and papa humankind continues was written by Dame Mira following this claim to encapsulate the wairua of the moment. You will also hear in this evidence that it inspired her to go to the United Nations, and this is set out in the evidence of Ms. Hinamoa Awatere that you will hear this week, where they actually made changes to the draft Declaration of the Rights of Indigenous People and inserted a clause to ensure that the mana and status of women and children were in fact recognised and protected as part of that international agreement. I don't propose to go through paragraphs 28. I think those matters will be covered off, but I do wish to take you to the section on te whare tangata me te mana motuhake, unless the tribunal wishes me to, and to take you through a couple of the principles of te treaty. As Dale Takitimu affirms, mana wahine is not symbolic or metaphorical. It is lived, embodied, and sustained across generations. Central to this is the concept of te whare tangata, the house of humanity, or the house of humankind, is what Mira would often translate it as, which speaks to the womb as both a physical and metaphysical site of creation, connection, and continuity. Through te whare tangata, wahine became the bearers of whakapapa, anchoring our relationships to one another, to our tūpuna, and to those yet to be born. This role is not simply biological. It is cultural, spiritual, and deeply political. Within tikanga, te whare tangata is sacred. It requires active protection because it is through the institution that Māori's future are nurtured. It ensures the survival of us as a Māori people, a Māori nation. To uphold mana wahine is to uphold the foundation of whānau, hapu and iwi well-being. In conceptual terms, mana motuhake is the practice of protecting te whare tangata, and with it, te mana o te wahine. It is through mana motuhake that wahine can define and determine their roles, responsibilities, and contributions on their own terms. When women are empowered to exercise this authority, the collective mana of Māori people is strengthened. Mana wahine is not a subset of mana motuhake, it is central to it. The power to create, sustain and protect whakapapa through te whare tangata is foundational to Māori existence. To restore Māori self-determination, we must restore the rightful place of wahine as knowledge holders, decision makers and protectors of life. Protecting mana wahine is not symbolic, it is a constitutional imperative essential to the future whānau, hapu and iwi. I set out in the relevant duties, and again, I just want to emphasise, we don't like the principles. We are fundamentalists when we come to interpretive philosophies around te tiriti. It's the text that drives its interpretive value, and it is the Māori text that is only of value. And you will hear from a number of witnesses, starting with our esteemed Ani Mikaere and Dr. Paparangi Reid on that this afternoon. I actually think in the hierarchy of values at 44, I'm not too sure we've got this right. Tino rangatiratanga as a phrase came through Te Tiriti o Waitangi, and mana Māori motuhake came in he whakamaputanga. We're going to use as conceptual frameworks where those matters arise, and Salmon's discussions on this in the Paparahi o Taraki emphasise that. So I think if I was rewriting this part, I would put mana motuhake first, and if there was a prioritisation of the conceptual frameworks that guide our understanding of mana wahine. Mana motuhake demands authority over decision-making, leadership, knowledge and resources that affect Māori communities. It is not only political independence, but also the ongoing ability to maintain and express identity, culture and collective well-being. This principle includes the inherent responsibility to protect, recognise and nurture the mana of wahine. And I want to talk about the interrelationship between tino rangatiratanga and mana motuhake to guide an interpretive outcome from the tribunal in your report. Rangatiratanga is, I think the best interpretation still comes from Te Paparahi o Te Raki report of Judge Cox said in his panel. But some of the earlier panels, like the Manukau Authority, like the Taranaki Tribunal into the Motunui Sewerage Scheme, all of those actually reflect the nuances that the Paparahi o Te Raki claim also came to its conclusions around. Tino rangatiratanga recognised the absolute, and I think the tino is the absolute, it's the emphasiser and enduring authority of wahine Māori over their taonga. It demands respect for te mana o te wahine and the role of wahine Māori in decision-making, leadership and guardianship. And, you know, just as a lexicon matter, our language does not distinguish between men or women. When you use words like ia and tangata, they are neutral and they should be all-encompassing of both genders. And one of the difficulties is that as colonisation has progressed, rangatira has seemed to take a male-dominant aspect, undermining the recognition of women in rangatira in their own rights. We think that the tribunal's approach to anchoring the principles of the treaty by virtue of your statutory requirements under Section 6 should not limit your ability to imagine, as we want now, a new approach to the determination of tino rangatiratanga and mana motuhake, and the intrinsic interweaving of mana wāhine into the outcomes of those interpretive discussions. One of the key things that will emerge in the rangatiratanga po, and I'm going to stop at this point because I'm stealing the thunder of the better speakers coming after me, is I think that it will actually show you that what mana o te wahine does is set a whāriki. It is the basis from which te papa o te whare can be built for rangatiratanga. It's no, I think Moana Jackson used to use the language of papa being both philosophical assumptions about practice and action. That was what he used to say for papa. And I'm hoping that you might, in this inquiry, use that conceptual framework to assist you in finding new ways to meet the dreams, the moi moia, that the women claimants stand before you to achieve at this time. And at that point, unless you've got questions of me or you want to question the panel, I wish to hand over to my learned colleague, Ms. Coates, and she will take you through the rest of our submission.
Tēnā koe. I've just got a question about the 93 appointment process. So the Crown has raised the issue of whether or not there would be utility in more closely interrogating what happened and what has changed since then. You've said you're not going into the details of the hui, and I just want to know, do your claimants wish to go down the track of interrogating the 93 appointment process?
I think we have to, in terms of the way the claimant's been framed. But there are parts of the process that Crown agents were privy to, like the discussion, the segue between how Dame Mira was publicly announced one day before. Then there was some discussions, as I understand. And you need to understand there are some key individuals that are still around. Hekia Parata's one. Remember, it was the Labour government, Shane Jones, and they had significant roles in policy making, so we could interrogate. So that's the first part of the interrogation. Prior to that, there was significant hui. I know in Te Arawa that, Kathy Jews nominated me and we got a unanimous meeting that said I should be on it. That's groundbreaking. It's brought up at all of our hui, because Te Arawa seem to oppress women more than everyone, they tell me. But that would be helpful. But I've looked for that material, and it's very difficult to find, both in archival sense or even the nomination that was sent by Te Kokotahitanga o Te Arawa Fisheries, and where we were involved in significant litigation at that time to the Crown. So given our resources, yes, we would love you to interrogate that part. If that information could be located, that would be very helpful. Is it pivotal to our claim? I don't think if we can't produce it, it will mean that we are unable to prove our claim, but I think it will be absolutely damning of Crown misconduct during that period if it's located.
Thank you. I did just want to kind of ask you directly, given the Crown has raised it, you've raised it, and it was the catalyst for the claim, so I just thought it was worth asking the question.
Yeah, just going back a bit, there was the Sea Lords deal in Parliament, 99 men brought down on planes and very few women. I mean, all of that's written up in a number of the historical accounts of that period. Professor McHugh, for example, the Sea Lords and Sharks article talks about the marginalisation of Māori women in that process. Dame Sian Elias, even, who was one of the only women that was in the room advising, she's even made, I think, record to it. I mean, whether or not she'd be prepared to give evidence, I think hers might be subject to legal client privilege. But, there are some individuals, but that's also contextual to this. The fiscal envelope hui of Suhepi Te Heuheu, which discussed all of this in the Sea Lord deal, and the denial, those are also contextual matters that are helpful in the te runanga o ngā hāhi whakawhanaungatanga o Aotearoa, which was the Methodists, the Catholics, the Anglicans, the late Honeka and the late Uncle Vuko, what was his bishop? He was the first bishop, Vuko, sorry. They were certainly very concerned by the failure to appoint, and that matter's documented in the Hirangi proceedings, which I'll have to look up, but that's a booklet that was prepared by Tūwhare Tō for Hepi Te Hehu, who opposed the Sea Lord's deals for a range of matters. Mita's appointment was a minor one in his scheme. He was going on about the fact that Ngāi Tahu seemed to have everything sorted out for them, including Ellesmere being a part of a settlement arrangement for the freshwater outcomes in there. So there is a lot of material. It's not been brought together. I think I'm so grateful to Dr. Carla Haukamo, which you'll hear from this week. That's the first written effort to bring some of this material into a consolidated manner.
Any pātai, Linda?
Thank you.
Kia ora koutou katoa. I te tuatahi, he maha ngā mihi a tāhua a e rere ana I te ata nei. Mai tōku tuakana Miss Sykes, o te rā mai ngā kaikōrero katoa. E tautoko ana au katoa I e rā mihi. I'm not wanting to be repetitive because we really want to get our excellent witnesses up this afternoon. So I just wanted to support all of the beautiful mihi that have flown this morning. One of the ones that I did just want to reiterate and emphasise is a mihi to the original claimants of the Y381 claim. The courage and the tenacity and resilience that it would have taken to not only file that, but to do all of the mahi that those amazing wāhine have done across the course of their lifetimes needs to be acknowledged and needs to be recognised in the context of this claim. I mean, that was made, it's been a long journey. That claim was made many, many years ago. A number of the lawyers on that half were probably not even born 33 years ago. And we all stand on the backs of these giants who have really made an immeasurable impact, not only for Wāhine Māori, but on the broader landscape of Aotearoa life. So, ngā mihi kia tika, kia rātou. In terms of what I was going to cover, Your Honour, sorry, I'm used to standing this way. I was going to pick up just a couple of points, but spend most of the time focused on the section of our openings that talk about framing the claim. In relation to the treaty section, my learned friend has already traversed that. I think the only point that is just that to highlight, I think, or emphasise there is an obvious one or a trite one, that the promises of Te Tiriti were made to all, i.e. they were gender inclusive, which means, of course, that Te Tiriti affirms the mana and the rangatira of Wāhine Māori, and all of the principles and the obligations that flow from it apply in relation to Wāhine Māori. And the reason we squarely mention that, because again, it's an obvious one that shouldn't necessarily need to be highlighted, but in the context of this hearing and in the context of the absorption of the Wāhine Māori experience into the general experience, we wanted to make that point explicitly clear. So in terms of the Y381 claim, we've filed 12 briefs of evidence for this particular hearing, all from Wāhine Māori, all talking about the experience of Wāhine Māori, so about Wāhine Māori. And whilst all of the witnesses speak from different locations and disciplines and experiences, although many have a similar experience in the activism space, they're all united in the message that the Crown has deliberately and systematically eroded the rangatiratanga of Wāhine Māori, both past and present, and it continues. So we're fortunate today to have Dr. Ani Mikaere, who will be talking this afternoon about how colonisation and the patriarchy distorted tikanga Māori and displaced wahine from roles of authority and upset the constitutional balance inherent in our world. Professor Pāpārangi Reid will also this afternoon draw on her extensive experience, particularly in the House space, to demonstrate and talk about how inequities are structural and constitutional and not incidental. Our pōpō, first up, we're fortunate to have Tina Ngata, who will situate the marginalisation of wahine Māori within the global doctrine of discovery and how that doctrine of discovery is embedded or was embedded with ideas of patriarchy, hegemony, racism, and how that continues to impact us today. Ripika Evans will draw on decades of activism to show how wahine Māori have been excluded from treaty negotiations and Māori governance structures, despite being central to the resistance movements that made those processes and structures possible. Tania Rangihiua highlights the systemic underrepresentation of wahine Māori in governance and exposes the Crown's failure to collect or report data that reflects wahine Māori realities, which has an invisibilising effect. Dale Takitimu, her evidence is embedded with powerful poetry and prose, and through that medium, as well as legal analysis, she offers critical commentary on the erosion of tikanga by the Crown and the erosion of mana wahine. Donna Awatere Huata tracks the historical imposition of colonial law and the Christian patriarchy, showing how these systems subordinated wahine Māori and entrenched gender equities across generations. Dr. Carla Hokomo uses Dame Mitasazi's exclusion from fisheries governance to highlight structural marginalisation. So as my learned colleague said, she delves into that fisheries experience. Dr. Aroha Harris reframes the League as a strategic site of resistance and mana wahine activism, not just a service organisation. The collective brief from the League presidents documents 70 years of unpaid, under-resourced nation-building work led by wahine Māori. And Grayson Papuni McClellan offers a rangatahi perspective showing the intergenerational legacy of exclusion and resistance. So that's what you're going to hear over the coming days. And we're very, very fortunate that many of these very, very busy wahine Māori, all holding things down on their own multiple fronts, have given us the privilege and the time of appearing to have their voice heard and contribute to this inquiry. Their evidence, of course, is not the totality of the supporting kōrero for Y381, but it is a fabulous start. So this brings me to my section of our opening submissions on framing the claim. What we do in that part of our opening submissions is make 9 key points around how to conceptualise not only the Y381 claim, but also the mana wahine kaupapa inquiry more broadly. And we do that in part because this isn't an easy issue to get your head around. It's not a singular focus kaupapa like the Treaty Principles Bill or the Takutai Moana inquiry or even health, which has an expansive scope. To a certain extent, this is an everything claim. For the first time, as my learned colleague said, we're looking at the specific and unique experience of wahine Māori and the Crown impact upon us, and that spans life itself. Not only are we looking at what the Crown has done and our marginalisation, exclusion and silencing across multiple spheres in the kāwanatanga space, this claim is also forcing us to turn the mirror inwards. So looking at the impact of the Crown on ourselves and our own tikanga, that raises deep and difficult questions that really go to the heart of our identity. Some of those issues have already arisen in this inquiry, i.e. this morning, when there was a request for a space where wahine Māori could whai kōrero, which couldn't be accommodated because of the kawa of this particular marae.
This claim speaks to those issues, speaks to very difficult questions around whether those are examples of the internalisation of rigid colonial gender norms or not. Is it Western feminism trying to impose itself now? What is us? What is them? Can we change? Should we change? This claim brings up some of those hard and polarising issues about our own identity and our own tikanga. And the evidence will show that the Crown has contributed to the erosion of the mana and rangatiratanga of Wāhine Māori, both within the kāwanatanga sphere and our own rangatiratanga sphere. That is a treaty breach. Acknowledging that the patriarchal ideas infiltrated our tikanga and how we conduct and order ourselves in our whānau hapu and iwi is a necessary part of our healing journey as a people. So we're not expecting the tribunal to necessarily solve it all, but acknowledging the Crown role in where we have got to, where we have come to, and where we are is an important acknowledgement that is being sought. Although this kaupapa inquiry may seem vast and complex, what we're hoping to do with the sort of 9 points that follow is show that it's not that difficult to navigate if you have the right compass. So our thinking was to set out some guiding themes that can hopefully point us in the right direction as we're traversing the claim. And these will no doubt they're no doubt not the only ones, and they will no doubt be developed over the course of the hearings, but hopefully they provide a starting point to conceptualise the multiple strands and things that are being grappled with in this inquiry. So the first one is that the rangatiratanga of Wāhine Māori was systematically eroded through colonisation, and the Crown played a significant participatory role in that. The Crown's introduction of colonial legal systems and foreign ideologies actively dismantled the constitutional balance that had existed in Te Ao Māori. And it's important, and my learned colleague did this in her comments as well, to briefly address the romanticism point that was highlighted by the Crown in their opening submissions. To be clear on that, wahine were rangatira and tohunga, and the evidence clearly shows that we existed in balance, not only with Tāne, but with Te Ao, and that point should not be overstated. Colonisation, on the other hand, was not neutral. It was patriarchal, Christianised, hierarchical and racist. It deliberately displaced Wāhine Māori from roles of mana and authority that were grounded in whakapapa and tikanga, and we have a number of witnesses that will be speaking to that theme. Tina Ngata, for example, will talk about that philosophy that sits behind the doctrine of discovery, which justified the expansion of empire and cast Indigenous women, including Wāhine Māori, as immoral, inferior, sexualised, subordinate human beings. And she'll talk about how we built our modern nation upon that scaffolding of denigration. Animi Kairi is also going to speak about that concept of hierarchy and how it was essential that we learn to accept our place on the lower rungs of humanity, and how the introduction of the patriarchy was a critical step in that process. Importantly, the Crown played a key role, saw in their submissions this morning and in their opening statement, sort of pointing elsewhere to other influencing factors such as urbanisation, religion, global forces. And that's not wrong, but the Crown were in there leading the charge and played a key role in this process. They didn't merely observe the shifts, but imposed and embedded them. The result was not only the exclusion from the kāwanatanga sphere, but also the disruption of tikanga-based governance structures within Māori society itself. So that's theme one. Theme two, Wāhine Māori experienced intersectional and layered discrimination. So Wāhine Māori have experienced discrimination on multiple fronts. As Māori, as Wāhine, and in an intersectional and overlapping way as Wāhine Māori, which has a magnifying type harm. Importantly, then this is a theme that will come up, I think, on not just in this hearing, but in all of the multiple hearings that follow. You'll see discrimination that is not only direct and explicit, but also
structural and covert. So the direct and explicit discrimination can be seen in things such as what Donna Awatiri Huata will talk about, the doctrine of coverture. It's explicit when we were excluded from voting and holding office or inheriting land. But much of the discrimination is more insidious than that. It's structural and covert. It's hidden and inherent in systems that may appear neutral on its face, but systematically disadvantages wahine Māori. And that's often harder to point to, but is something that the tribunal will need to be aware of, and it will be raised on numerous occasions. So, for example, voting. Although wahine gained the right to vote in 1893, and then over 30 years later, in 1919, there was the right to stand for Parliament, it took 30 years for a wahine Māori to be voted in to Parliament. So whilst on the face of it the opportunities may have looked equal, and structural barriers were dismantled to voting and being in Parliament, it wasn't. Discrimination can lurk in the shadows and in the systems and in the cultures which produce inequitable outcomes. Dr. Paparangi Reid is going to give health examples of that, how you can have neutral things like screening ages, which appear to be even and neutral and apply equally to everybody, but it doesn't in terms of wahine Māori and Māori more broadly. So the point there is that the inquiry will demand that we look beneath the hood of the car in a number of different ways, behind the facade of neutrality and equal opportunity to that unique experience of wahine Māori, and really look at those layered forms of marginalisation and the power of them, because they are often invisible and they are often unspoken, yet they determine whose voices count, and the wahine, whether wahine Māori have voices that are not only present, but appreciated, understood, and have the power that they should have. The third theme is around the erasure and silencing of the voices and experiences of wahine Māori. The voices and experience of wahine Māori have long been erased, ignored, or overlooked. That has a long whakapapa, back to when early Pākehā historians were writing about us. Wahine atua, wahine tipuna with a footnote, or the side stories, and not having main character energy. The Crown is the same. There is a systemic invisibilisation of wahine Māori in data, in histories, in research, in policies, and the law, and that's a structural violence in and of its own self. That theme will come through strongly in the evidence, because it's often difficult to bring evidence when the data is just not there. It's difficult to understand our experience when the Crown doesn't keep data on it, and that erasure and silence diminishes our ability to challenge decisions, obscures often the scale of inequity, and limits how we respond. And that invisibility is not an accident, but reflects institutional disregard and a failure to honour the treaty promises of protection and partnership. Fourth theme, mana wahine cannot be realised within kāwanatanga sphere alone. The Crown cannot fulfil its treaty obligations just by having more brown wahine faces within its own structures. Yes, representation in that sphere is important, and the principle of good governance requires that inequity and lack of representation there is addressed, but that is not the totality of the issue, nor is it the end game. Tino rangatiratanga is not realised through participation in colonial legal systems alone. It must be affirmed through genuine power sharing, constitutional transformation, and the resourcing of wahine-led structures and initiatives that reflect our own tikanga, our own values, and our own aspirations. So the recognition of mana wahine must occur in both spheres, the rangatiratanga and the kāwanatanga sphere, and the relational space in between them. My fifth point, recognising the interest of wahine Māori strengthens democracy and merit. We make that point because of the current political rhetoric around all things Māori being anti-democratic. This claim challenges narrow understandings of leadership, legitimacy, and merit, and systems that have excluded wahine Māori for over 180 years cannot claim to be merit-based or neutral. Instead, they have privileged one worldview, one way of speaking, leading and knowing. And recognising wahine Māori expertise and leadership is not an exception to democracy, it's a requirement for its legitimacy. Equity is not about special treatment, but about ensuring fair access, fair recognition, and fair power. The sixth point to be made is that the claim must be viewed holistically. And what we mean there is a couple of things. The first is we caution against viewing this claim as the oppression Olympics. It's not a race to the bottom or about establishing that wahine Māori are worse off than tāne Māori. And the Crown, in their opening statement, sort of pointed out that wahine have worse statistics than the general Māori population in relation to incarceration, for example. That's not the point. We encourage the tribunal to think about this claim holistically and to view wahine Māori in an interconnected manner. The experiences of wahine Māori are impacted by harm inflicted on tāne Māori, on tamariki, on kaumātua, on whānau, iwi, hapu. So, for example, the disproportionately high mortality rate of Māori men, or that a generation of Māori men went off to war, or that we have high incarceration rates of Māori men, those things profoundly impact wahine Māori because we bear burdens that flow from those things as well. So you can't just focus in an isolated way on the kind of statistics solely focused around wahine Māori, but we're talking about the well-being of wahine Māori being inseparable from the communities from which we come from, and the claim needs to take account of that. So it's not a zero-sum struggle, it's a return to collective health and justice. Point number 7 is the point that wahine Māori have suffered widespread systemic discrimination and inequities. We've made this point already, but it's worth just emphasising as a key theme, that across all of these spheres of life, and it'll be a theme that comes through, I think, strongly in some of the hearings that follow, cultural, spiritual, political, environmental, economic, and social, wahine Māori experience deep intergenerational harm. And those systemic patterns must be named, understood, and dismantled. The 8th point, 2 more, getting there. The 8th point is around the enduring resilience of wahine Māori. Wahine Māori have exercised extraordinary resilience over time, often carrying the burden of Crown failure, leading responses, creating solutions, and upholding communities together through generations, and the League is a really good example of that. This often underpaid, under-recognised labour has been essential to Māori survival and should be recognised and supported and acknowledged. Whilst that acknowledgement is important though, it cannot be the benchmark for justice, and resilience has come at a huge cost. And quite frankly, there are too many wahine out there who did not survive and who are still struggling. Wahine Māori are entitled to live with dignity and support and the full realisation of their rights under Te Tiriti o Waitangi, and survival must give way to flourishing. The final point, and this is a point that my learned colleague Ms Sykes touched on, is that the wahine Māori claims must be heard in their own right. And that's partly in response to the Crown referencing the multiple occasions where the tribunal has already examined issues raised in varying inquiries, such as land loss or voting. They raised it again in relation to treaty settlements and a broad statement about how there's been some acknowledgement of the erosion of traditional tribal structures. Whilst we acknowledge that there is some overlap and some research and work that has been done and jurisprudence developed that can be helpful, this claim cannot be subsumed into other inquiries heard by other judges, looked at through different lenses. It's kind of the point. These claims are being heard here, they're being brought here, grounded in the lived realities of wahine Māori and deserving of dedicated findings. And to assess them through any other lens would be to repeat the very marginalisation that these claims expose. They're not footnotes to other claims or side issues that quite frankly get little attention, but they're central constitutional claims in their own right. And that in and of itself makes it sufficiently distinct from all the other inquiries being heard. So those were the main points that I wanted to make to assist in hopefully helping the tribunal conceptualise some of the big tricky issues that are before you. And I was going to, unless the panel has any questions, hand it over to my learned colleague to talk about prejudice and remedies.
Tēnā koe. I was very interested in your discussion about the appearance of neutrality, and you applied it to voting, and maybe I'm hoping evidence will be brought later in the inquiry, but I just wondered whether you could discuss inheritance within that framework that because you mentioned that, and that's something that I've struggled with in terms of succession and how that works.
Do you mean inheritance in terms of whenua, land?
Yes.
I mean, there'll be a whole po, I think, on the whenua, the whenua dimension where that will be teased out. I think the inheritance point was linked to the coverture point, just around some of the barriers of Wāhine Māori being shut out from land inheritance, despite Wāhine having specific roles and connections to whenua, and then the sort of Pākehā property system codifying that in particular ways, which meant that Wāhine Māori were often excluded from title and therefore disconnected from their whenua. So I think that was the point we were sort of alluding to in our submissions.
Okay.
So that's some of the more covert stuff.
I have further questions, but I'll wait till we get to the whenua part of the hearings. But thank you, that was very interesting. Thank you.
Kia ora. Kia ora. Thank you.
Kia ora. Just before you start, Ms. Chestnut, I just note that we are due to go for kai at 1 o'clock.
Your Honour, you'll be very pleased to know I will be brief. I really do only have a couple of points that I wish to make this morning. I do note that my learned friends have amply covered a lot of what the claim is about, so I really do only have 3 points that I wish to pick up on. I am to speak to the prejudice and the remedies set out in the opening submissions. However, I'm not going to take you through what I no doubt you have already read in terms of what we set out as the prejudice. But there is a point that I wish to make in relation to the pattern of the Crown exclusion and the harm. As my friends have noted, this is not a claim about isolated injustices. It's about systemic and intergenerational pattern of exclusion, of harm and of suppression. The Crown patriarchy and the systemic exclusion has not only marginalised Wāhine Māori at every level, but it has done so across generations. The point I wish to make here is if we bring it back to the genesis of this claim, and that is the exclusion of Dame Mita Zazi, when even a leader like Dame Mita is excluded from decision-making spaces, it reveals how deep the exclusion of Wāhine Māori truly runs. The Crown's unilateral decision-making of the Treaty of Waitangi Fisheries Commission's appointments in 1993, behind closed doors, in blatant disregard for her mana, for the rangatiratanga of her iwi, of the League who also nominated her, is is symbolic of the deliberate and the planned marginalisation of wahine Māori within the Crown's sphere of control. If even the voice of Dame Mira, who's a pioneer, a recognised and celebrated wahine toa, could be sidelined, then what hope is there for other wahine Māori? This is not just about the historical injustice, it's about the structural reality that continues to diminish the value, the voice and the visibility of wahine Māori. And that must change. As counsel for the League in this inquiry, it's really important to note that the League is a national body. It represents the wāhine, and as is noted in the brief of evidence filed by the past and present presidents of the League, the members of the League are the League. The League is the members. So when you have a wāhine as powerful as Dame Mira excluded, then where does that leave the everyday wāhine? That's the first point I wish to make in terms of the prejudice. The second point I wish to cover, and I don't want to rehash what has already been aptly covered by Ms Sykes and Ms Coates, is in relation to the Crown's opening statement this morning. We note that acknowledges, at least in part, its role in the exclusion and the harm forced on wahine Māori. But those acknowledgements, they don't reflect the experience of the wahine Māori on behalf of who this claim has been brought. And they don't, in the written statement, acknowledge that they limit those acknowledgements to what has occurred in the past. I note my friend did speak of contemporary issues, but what is obvious from the Y381 claimant's position is as the more time passes, noting the 32 years that have passed to date, this damage becomes further entrenched. The prejudice, as set out in paragraphs 89 to 90 of the submissions, it's acute. It's the systemic and layered discrimination. It's the ongoing exclusion. It's the constitutional marginalisation. And it's the intergenerational harm that affects whānau, hapu and iwi. The prejudice that's suffered by wahine Māori as child rearers and carers is experienced across generations by tamariki, mokopuna and other whānau members. The result is a society where deep inequities persist and wahine Māori remain structurally silenced. The realities for wahine Māori were clearly articulated in the submissions filed by counsel for Y381 back on the 15th of December 1993, which, as my colleagues have pointed out, is a time before a lot of the lawyers in this room were even alive. That's attached to the opening submissions filed by Y381. Those submissions acknowledge that the situation for wahine Māori as at 1993 was dire. And over the coming hearing weeks, this tribunal will hear the evidence that displays the depth of the suffering of wahine Māori at the Crown's hands. The situation as it was in 1993 is arguably further entrenched today. It's still dire. An acknowledgement by the Crown that the imposition of Western political and constitutional structures as features of colonisation have profoundly impacted wahine Māori is the bare minimum expected. I have one final very brief point to make, Your Honour, and that's in relation to the remedies. I note that so what is being asked of the Crown is to remedy the prejudice to wahine Māori and to restore the guarantees to Māori under Te Tiriti, and that's as set out at 91 to 93 of the submissions. The remedies are organised under 4 headings. We have recognition, reconciliation, representation, reparation and reconstruction. I won't go through those, Your Honour, and there is a reason for that. The remedies, as set out in the opening submissions, are necessarily high level. They are indications to this tribunal of a way forward, but necessarily must be developed as the evidence in this inquiry is heard. The Crown questioned this morning what is meant by enduring constitutional transformation and how it's intended that it will be recognised and uphold the rangatiratanga of wahine Māori. Here, what we say is how mana wahine is embedded across all levels of governance, of decision making, or how we can achieve the TDC compliance. This will be developed as the inquiry continues. This has already been indicated to the tribunal in previous memoranda and in judicial conferences that it is something that is a process that will be further refined as the hearing proceeds. So in this regard, we tread carefully at this juncture. What we can say is what is being asked is something more than window dressing. It's not tinkering. It's not isolated wins or minor symbolic gestures. What we know is that representation without the structural transformation is not Te Tiriti compliance, but the details of that is what will be developed over the course of this inquiry. I note I've run about a minute over time, so in that regard, that will be the conclusion of my submission. So unless there are any questions, then these are the submissions on behalf of Y381.
Ka pai. Thank you, Ms. Chestnut. Just a question following up the point that you were making at the end there around the development of, in the remedy space. We have had some discussion in judicial conferences about potential processes around that, maybe a joint statement of remedies, convening of hui to discuss that. Are you able to give any update as to where that sits currently?
The short answer is I can't, Your Honour. It is a process that we are still developing, that it is intended that Y381 will be assisting with the rolling out of that process, but the details of which we have not yet at this stage been able to progress.
Yeah. I think one of the principles we're proceeding from is, as has been noted by several of the council this morning, this is such a wide-ranging and all-encompassing inquiry that it will be of assistance to us to have, a clear indication from the claimants as to, and I acknowledge there has been an attempt here to give us a sketch of the territory within which those remedies might inhabit, but certainly as we proceed, if more specificity can be given to us around that, more meat on the bones of what you've given to us, that would be really helpful for us. Yeah. Okay.
E hara I te mea he pātai he engari anō he pirangi kia mihi I te pai I te mārama o tērā whakatakoto, ki ōku whakaaro, I tino whai hua mōku, kia kite I te whānuitanga o ngā take ka tau mai ki tō matau aroaro no reira pirangi ana kia tuku mihi rā kia koutou tokotoru.
Thank you. Well, I haven't as yet heard the call from the other side, so...
can I introduce our next witness? That might take 5 minutes because I really want to pay homage to... we're so privileged to have Ani Makaere present for us, so I've got a little spiel that I'd like to put into the record. So
what a surprise!
If I could call her to the stand, I just want to honour her for a little bit. So can I have the privilege of calling Ani Makaere to take the stand, please?
Yes, let's do that.
Kāre te hihia, ki te hihia ki te whakarongo. Anei te whakarongo, anei nā kōrero.
Kōrero mai.
It is my honour to introduce again my close friend and mentor in the legal field, a wāhine tō who has dedicated her entire career to examining the intersection of Māori law, colonial impact and Indigenous rights in our country, and continues to be an active voice in contemporary issues affecting Māori. This is Ani's third appearance in this inquiry, and what an honour it is for all of us to be in her lecture, which is to come today. Ani is a prominent Māori legal scholar, and in her role at Te Wānanga Ōraukawa, teaching ahunga tikanga, Māori laws and philosophy, she is responsible for leading and promoting tikanga-based curricula, which nurtures and grows the mātauranga continuum, the constantly evolving body of knowledge that has been produced by successive generations of Māori theorists and legal practitioners. In 2016, she was awarded Te Kaurutanga, a degree conferred by the founding iwi of Te Wānanga Ōraukawa, a degree for her thesis entitled Like Moths to the Flame, which investigates the impact of colonisation on Ngāti Raukawa thought. It is an epic piece of work. Ani has published widely on the impact of colonisation on Māori and Māori legal practices, biculturalism, Māori self-determination and the Treaty of Waitangi, Te Treaty o Waitangi. Her work discusses issues such as the ability of Māori to achieve justice when Māori law is marginalised, the need to confront racism in thinking, processes and structures, the impact of interpretations of the Treaty o Waitangi, the difficulty of redressing harm to Māori within the Pākehā legal system, and the importance of reinstating tikanga at the heart of Māori legal thinking and praxis. Ani advocates for tikanga-based approaches to governance and relationships, working to change what she calls the default setting toward more Indigenous-centred ways of operating, and stands alone as one of New Zealand's most respected Māori legal scholars, combining traditional knowledge with contemporary advocacy to advance Māori rights and self-determination in the legal field in the 21st century. An example of how popular Ani's thinking and writing is with the next generation, her recent oral submission to the Select Committee on the Treaty Principles Bill amassed over 200,000 views in just 2 days across the Labour Party and Māori Party pages, never mind we don't know about everyone else's, and up to over 600,000 views and growing, putting her at the most viewed submitter on TikTok out of 500 oral submissions. Her prolific output demonstrates remarkable intellectual range, and perhaps most admirably, Ani operates as a bridge between Indigenous and Western legal traditions without compromising Māori legal traditions. My friend represents a new generation of Indigenous women scholars who refuse to be constrained by Western academic convention. She writes with the authority of someone who deeply understands both systems, the courage of someone who has experienced colonial violence personally and collectively, and the wisdom of someone committed to ensuring future generations inherit something better. Ani makes me a better legal advocate in every way and doesn't hold back to tell me when I need to level up. The appellation number to Ani's brief of evidence is C4, and without further ado, I would ask that she be asked to give evidence after the luncheon adjournment. Nā mihi e te mārei kura o Raukawa, o te ao Māori, tēnā koe. Kia ora.
Well, tēnā koe, Ms. Sykes. So I understand that Kai is ready, so we will adjourn now for, well, how long? For an hour. We'll be back at 2 p.m. when we will hear from Ani Mikaere.
Tēnā tātou. Ia Robin e hara mai ana, he pirangi ana kia tāpai taku hara i te āhuatanga o te pōhiri, i mahue i au tētahi mihi nui ana ki runga anō i tētahi aitua. E tika ana kia mihi ana te mea kua roa e kawe ana tēnei kaupapa me tana noho ki roto e arataki ana i te manatū Wāhine. Nō reira e tika ana kia mihi ki te pou o roto o Ngāti Porou o te tairāwhiti, ana ko Bill Kaua tērā. Tērā ahako kua hipa te wā, koenei te tuatahi o ngā tino hui, kia kōrero i tērā. I aro ke au tu au ki ngā Wāhine, engari anō koia tērā i kaha arataki i te manatū. Nō reira kia iri anō ko te pare kaua o roto i aia, ana ki te taha anō o nei pau kuia o te kaupapa. Nō reira, tēnā e te whare, e te minenga, tēnā kua rongo o te taringa, kua rongo te ngākau me kawe tonu a tātou kōrero. Tēnā tātou. Hara mai, Robin.
Tēnā koe ane, kia koe. Kei toro mai? I te tuatahi me mihi ka tika ki te hunga nāna tēnei kaupapa i whakarewa i te tau i wita kaumātoru. Me kore ake tō koutou manawa nui, tō koutou whakaro nui, ki te whai i tā koutou i pirangi ai. Arā, ko te whakatika i te he, kia pai ai tō tātou noho ki tēnei ao. Ka huri aku whakaro ki ngā wāhine, pērā i a tuaiwa, ngā tua wāhine me ki, pērā i a tuaiwa, pērā i a ngā pare hopa, pērā i a Robin kahukiwa. He momo tērā kia hau, ko rātou te whakatinanatanga o tēnei mea, te mana wāhine, nā rātou anō te huarahi i para, ko tā tātou, he whai i taua huarahi, he whakawhānui i te huarahi, mō ā tātou tamariki mokopuna te take. Nō reira, i ngā mema o te rōpū whakamana i te treaty, tēnā koutou. Kia koutou kua hui mai nei i tēnei rā, ki te hunga kua hono mai nei, ki te tautoko i tēnei kaupapa, anei te reo o Ngāti Pariraukua, o Ngāti Huia, o Ngāti Raukua me ki e mihi atu nei kia koutou, tēnā koutou katoa. It's kind of hard not to feel a little overwhelmed by the enormity of this moment. I'm conscious that we carry the hopes and the dreams, not just of the last 32 years, but of all the generations who've gone before us. So we owe it to them to nurture those hopes and dreams, to expend all of our efforts in an attempt to realise them, but more than that, to take those hopes and dreams and to reimagine them and to project them forward into the future, because that's what these wāhine here, the Y381 claimants, did for us. So we have a responsibility now. We must do everything in our power to make sure that the wait has been worth it. I'm not in any way exaggerating when I say that the lodging of Y381 changed the trajectory of my career and indeed of my life. So it's an enormous privilege today to stand and speak in support of the mana wāhine claim. My brief today is to speak on the rangatiratanga of Wāhine Māori and on the impacts of colonisation on Wāhine Māori. Contrary to what Annette has suggested, I've never once presumed to tell her what to do. The true nature of our relationship is, she says, I would like you to do X, and I say, okay.
So this is my brief. This is the brief that she's given me. I'm proposing to cover this material in 4 parts, which is in paragraph 6 of my brief. I know time is a little short, so I won't run through the parts, but I'll indicate each time I get to a new one. And the brief will build on and should be read in conjunction with the brief that I presented before this tribunal back in 2021 at the Tuapapa hearing in Kirikiri. So the first part of my brief talks about Māori creation theories and mana wāhine. And some of it is going over ground that we covered in 2021, but it's necessary just to establish a bit of a platform. So, as I've said many times, creation theory is the obvious starting point for any discussion of tikanga, because creation theory is the philosophical foundation from which our tikanga is drawn. Creation theory, as we know, is the response of our tūpuna to the universal human conundrum of explaining who we are, how we came to be, and probably most importantly, how we can best ensure our long-term survival. Our creation theory holds the accumulated wisdom of countless generations designed to guide our behaviour towards one another and the world around us. In my previous brief, I noted that whakapapa is a common feature within iwi explanations for the beginning of the world, that whakapapa binds us to the spiritual forces from which life as we know it emerged. One consequence of this is that both female and male energies are identified as crucial. Without both, there can be no whakapapa. Another consequence is that the whare tangata is identified as pivotal. The metaphor of conception, gestation and birth being utilised within many creation theories to make sense of the beginning of the world. In that brief, I concluded, our creation theories establish the centrality of women to whānau, hapu and iwi, positioning them as agents of transition between the physical and the metaphysical, between the unconscious and the conscious, between tapu and noa states, between life and death. That brief focused on the uniting of Papatūānuku and Ranginui to draw out the significance of whakapapa as a foundational concept in Māori creation theory. Now, my primary focus in that presentation was the common themes that could be discerned from creation theories, but it is important to note that there is no single creation narrative. There are many iwi accounts of creation that can readily be found. So, for example, some iwi speak of Papatūānuku having a relationship with Tangaroa prior to her union with Ranginui. Some refer to Ranginui's first partner being Wainui Atea, with whom he had a multitude of daughters. For some, the female essence is personified by Puna, the male essence by Hani, with Rangi and Papa not coming along until a bit later in the story. For some iwi, maunga or awa are ki atua in their kōrero, for others, mist and rain and so forth. The gender of particular figures is not always necessarily fixed either. Many accounts refer to Muriranga Whenua and Taranga, for instance, as female, but according to Te Rangi Haeata, whose kōrero I relied on in my earlier brief, Muriranga Whenua was in fact a male, and it was his union with Mahuika that produced Maui's mother, Hine. Taranga, according to Te Rangi Haeata, was Maui's father. Variations like this, as from one iwi to the next, are not at all uncommon. And in fact, it appears, when you look at these older materials, that the notion of gender itself may not have been as regarded, or not have been regarded by us tūpuna as fixed, as we sometimes now imagine that it was. So according to Pei Te Huranui Jones, for instance, both Rangi and Papa were at one time, in his words, bisexual or asexual, each of them giving birth to children. Huranui also writes of a sexual union between two males, Kahukura and Tāne Mahuta, who produced a daughter, Hineari. This he describes as a bisexual conception. Now, the reason why I am acknowledging the diversity of creation narratives is because this tells us something really important about the mindset of our tūpuna. They understood that each and every iwi had their own particular relationship with atua, and that relationship was nobody's business but their own. There's no suggestion that one account was better than another account. There's no desire to try and foist one person's account on the next person, or to try and make everybody believe the same thing. But having said that, there are certain themes that appear to be common to all, and whakapapa is a key one of those. So having identified whakapapa as a key theme and the implications of this for the significance of women, my earlier brief focused on the example specifically of Hine te iwa iwa to illustrate the rangatiratanga demonstrated by our wāhine, our atua wāhine. There are so many other atua wāhine within creation narratives who can be pointed to as models of mana wāhine in action, and you would have heard of many of those during the Tuapapa hearings. So, for example, Papa Tuanuku, who waited until the time was exactly right to instruct Tāne Mahuta on how to shape the first human form from her menstrual material at Kurawaka. Or Muriranga Whenua and Mahuika, both of whom recognised in Māori that something special that meant he would be able to utilise the knowledge that they had been carrying for ages for the benefit of their human descendants. We could take the example of Hine Titama, who carved out for herself a new pathway, a pathway that would enable her to maintain an intimate relationship with her children while giving herself space from the man who had betrayed her trust by not revealing her true whakapapa. Or we could look at Hine Nui Te Pō, who taught Māori his final lesson, and in doing so provided a safe haven for all of her mokopuna when they transition out of Te Ao and back to Te Pō. So as with Hine te iwa iwa, the stories about these atua wāhine and many more established beyond a doubt that our tūpuna understood very well the mana, the rangatiratanga of Māori women. They recognised women as atua, as creators, as tohunga, as holders of knowledge, as instructors, as military strategists and political leaders, as protectors of whakapapa, and as visionaries. Turning now to consider tikanga that expressed the rangatiratanga, the mana of wāhine Māori. My earlier brief, you may recall, focused primarily on Waitohi and on the compositions of her brother, Te Rauparaha, to illustrate the way that our understandings about the authority of women translated into tikanga that were utilised within daily life. As I explained there, Waitohi utilised the tikanga described as tai tamatane whai I te ure tū, tai tamawahine whai I ana were were. So this was a tikanga that our old people referred to, which is talking about the fact that as a general rule, men would follow their father's side and women would follow their mother's side. Now, Waitohi understood this tikanga and she utilised it to very good effect, issuing a tono that mobilised her formerly reluctant Ngāti Huia relations into migrating from Waikato to the Kapiti coast in order to help Te Rauparaha hold the lands that he had acquired there by Raupatu. Now, importantly, Waitohi was able to succeed where her brother had failed repeatedly, and she managed to succeed because of her understanding of this tikanga and her ability to couch her request in terms that could not be rebuffed. When you think about it, for entire hapu to undertake such a risky and arduous journey, moving many hundreds of kilometres to an unfamiliar land, purely on the strength of a few words uttered by a single person on a single occasion, is quite extraordinary. It drives home the point that Waitohi was a person of significant mana. Now, she reciprocated the loyalty demonstrated by her Ngāti Huia relatives by allocating land to each of them, setting in place the boundaries of Ngāti Raukawa hapu, and also those between ourselves and Te Atiawa to the south. These boundaries have endured to the present day. It's small wonder that Waitohi has been identified as one of her brother's chief military and political strategists. She quite literally changed the course of our history, causing us to migrate to the Kapiti coast and drawing a map of interlocking land interests that continues to shape the way that Ngāti Raukawa hapu relate to one another and to our neighbours, Te Atiawa ki whakarongotai. Now, Waitohi's daughter, Rangitopi Ora, was also a woman of mana. She took to the battlefield alongside her mother and male relatives when required. She was known for issuing commands for utu to be exacted from enemies through the composition of kai ora ora. Commands which, I might add, were always fulfilled by her uncle Te Rauparaha and her brother Te Rangi Haiata. But like all rangatira, she could turn her hand to diplomacy when necessary and played a key role in securing peace on a number of occasions. According to Te Wāri Kāki, she was involved in the tikanga employed to remove the tapu of the battlefield from men who had returned from war, and he needed to go through the appropriate rituals so that they could get back to normal daily activities. This was achieved by the men passing between her legs, a kind of spiritual rebirth, if you like, reinforcing the role of wāhine as agents of transition. Rangi Topeora was a political leader in her own right, not averse to standing up to her uncle and her brother if her opinion differed from their own. She wasted no time in stepping forward to sign Te Tiriti o Waitangi when it was brought to the Kapiti Coast by Henry Williams in 1840, May of 1840. And she made a habit of engaging directly with Crown representatives when she felt it was necessary to do so. When the missionaries were eagerly going about their work of converting Ngāti Raukua to Christianity, Rangi Topeora saw an opportunity to demonstrate her mana in terms that Pākehā might understand it. She agreed to be baptised, but only on the condition that she take the name Queenie Wikitoria and that one of her husbands would take the name Albert. Thereafter, she was widely known as the Queen of the South. And just recently I came across a whakapapa that had been recounted by Te Rangi Haata, her brother, and in it he just refers to her simply as Te Queenie Topeora, which I thought was kind of nice. While these examples are relatively recent, there are also stories demonstrating the mana of women dating back to the time when our tūpuna first arrived here in Aotearoa. One such example is what I think is a fairly well-known instance of the hauling of tainui waka across the narrow strip of land that runs between the Waitemata and the Manukau harbours in Tāmaki Makaurau. It's recorded that Marama, a wife of Hoturoa, had disembarked at Waihihi on the western side of the Hauraki Gulf, travelling overland for a period before rejoining the waka at Otahuhu. From there, it was determined that the waka would be hauled across the isthmus, I was worried about saying that word, in order to continue the journey along the west coast of Te Ika Maui. But the crew were unable to move the waka no matter how hard they tried. Now, according to Te Rangi Haata, Marama had harnessed supernatural forces to prevent the waka from being moved. He doesn't give us any explanation as to why she took this course of action, but there are a number of accounts that say that while she was travelling overland, she had taken a lover. And some versions say that that lover had been put to death as punishment. So maybe she was protesting her lover's fate. Or maybe she just lost enthusiasm for carrying on with the crew. We don't really know, but what we do know is that she is the one who caused the waka through the force of karakia to be held in place. Now, in view of the fact that Marama had been responsible for rendering the waka immovable, it's probably no coincidence that no man present was able to move it. In the end, according to Rangi Haata, it was another wahine, Whakaotirangi, who stepped forward, recited karakia, enabling the waka to be moved again. Now, Te Rangi Haata's description of this event is fairly brief, but it's very, very revealing. It reveals that both Marama and Whakaotirangi are adept in the use of karakia to achieve their ends. It's Marama who fixes the waka in place, and it takes Whakaotirangi to move it. Like Waitohi, the actions of these women changed the course of history. I find myself imagining, what if Tainui Waka had not been able to cross the narrow arm of land to the west coast, eventually making landfall at Kāwhia? I wonder where my Tainui ancestors might have landed and settled if not for this momentous event. This story can be seen as a further demonstration of women utilising the tikanga of karakia to achieve their goals, following in the footsteps of Hine Te Iwa, who, as you might remember, I described in my earlier brief, was expert in the use of karakia. She used it to facilitate the birth of her son. She also used it when she captured Kai. When we look at the models of mana wahine provided by our atua wahine and then reinforced by the actions of tūpuna, such as Whakaotirangi and Marama, it's really no wonder that our kuia in more recent times exhibited such supreme confidence in their role as rangatira. Theirs was a world determined by tikanga, and in accordance with tikanga, women exercised authority without hesitation. Their people expected nothing less. Moving now to the impact of colonial thought on Māori creation theories. As I've already noted, and I think someone actually mentioned it earlier as well, whakapapa is a foundational concept in our creation theory. It shapes every aspect of the tikanga that successive generations developed to guide the way that they interacted with one another and with the world around them. In my earlier brief, I explained that whakapapa prioritises relationships, our relationships with one another, our relationships with the world around us, relationships between generations past, present and future. Because we know that everything is connected, we understand that failure to nurture relationships will damage the intricate whakapapa web that binds us all. The certain knowledge that we are related drives us not to disregard, to exploit or to sever connections, but rather to pay close attention to them so that we may better understand the obligations that they give rise to. The reciprocity inherent in the maintenance of good relationships excludes the possibility of dominance or subservience. Whakapapa is necessarily non-hierarchical. I also explained in my earlier brief that the British colonists' view of the world was radically different to our own. They were extremely invested in the concept of hierarchy. To them, hierarchy bound them to one another through relationships of domination and subordination. The entire success of the British Empire was reliant on each and every person within the imperial machine understanding their place in the social pecking order, willingly submitting to some while demanding submission from others. And the success of the empire was also utterly dependent on target populations, such as our own, becoming rapidly wedded to the concept of hierarchy. It was essential that we learn to accept our place on the lower rungs of humanity. Essential that we came to believe that the colonists were inherently our superiors and that our submission to them was simply the natural order of things. But the colonists had a bit of a challenge. How do you convince a formerly non-hierarchical people of the benefits of hierarchy? As my earlier brief pointed out, introducing patriarchy, thereby gaining the support of half the population for the concept of hierarchy, was a logical first step. Now, it wasn't like this was the first time they'd done this. The value of patriarchy had already proven its worth in North America, missionaries instilling it there to combat what they described as the perverse intolerance of the tangata whenua there towards anyone who tried to assert superiority over others. Laguna Paul Gunn Allen has said, and I think it's a sad but true statement, the missionaries quickly realised that the most effective way of getting a people to understand and to respect tyranny was to encourage them to wield it against one another. As the advance guard of colonisation, the missionaries led the way here too. They played a key role in introducing patriarchy to the everyday lives of our tūpuna, civilising the natives, by urging us to reform ourselves into little nuclear families, by grooming our men to assume the control over those families, and by educating our women to accept our role as good Christian wives, docile, obedient, confined to the domestic sphere. By embedding the practice of bowing our heads in submission to a white, male, supreme being, the missionaries were also socialising the concept of white male supremacy. Racism and misogyny form the core of a religion that celebrates whiteness and maleness at the expense of colour and femaleness. Racism and misogyny were not confined to the missionaries, however. They underpinned the entire project of colonisation. As such, they defined the approach of the amateur scholars who made their careers out of becoming self-appointed experts on us. Men like Elsden Best and Percy Smith. These surveyor storytellers, as Di Grinnell calls them, published prolifically on our creation narratives. Their material cast the most extraordinary shadow over generations of others, including Māori, who subsequently relied on it to inform their own work. And I have a terrific quote here from Di Grinnell about the surveyor storytellers that I'd like to read out because it's just so good. She says this: "The stories of our land were retold to us by the surveyor storytellers whose lines did not follow the contours and names of our whenua, atua, and tūpuna. These retold narratives were built, layer after layer, based on misogyny, fear, racism, and hierarchy, redrawing the maps of our souls and memories. They imposed new lines where there had been none before, erasing markers that had guided us for centuries in a sustained process of intellectual and spiritual colonisation. Now, the work of these men on our creation theories dripped with condescension towards women. By way of example, the relationship between papa and rangi, which Rose Pere describes as both physical and spiritual and as mutually fulfilling, this was translated by Best and Smith into terms that placed all the power into Ranginui's hands. According to Percy Smith, the Ranginui which stands above felt a desire towards Papa Tuanuku, whose belly was turned up towards him. Seems to be the equivalent of a too short skirt, I think. He desired her as a wife, so Rangi came down to Papa. This characterisation of their relationship is flattering to neither Rangi nor Papa. Ranginui is cast as a sexual predator, while she is merely the object of male desire, available, unresisting, and entirely without agency. This pattern of portraying our atua wāhine as powerless participants in the male adventure of creation is repeated over and over and over again in the rendering of our narratives by these early ethnographers. When describing the creation of Hine Ahuone, Best explains Papa Tuanuku's role as that of sheltering, nurturing, cherishing. She represents the receptive and passive element, while Tāne represents the active, fertilising, creative male element. Now, when you think about it, that is a truly bizarre description, given that Papa Tuanuku has created Tāne. When Hine Ahuone discovers her true parentage, she is reduced to fleeing in shame and hiding herself away from the world. The contributions of Mahueka and Muriranga Whenua to the survival and well-being of their uri are completely minimised. The stories are centred instead on Maui, who is portrayed as a superhero, a rather self-obsessed superhero actually, who deceives and manipulates these feeble or foolish old crones into doing whatever he wants. Smith and Best also claims to have discovered a new version of creation theory, a version of creation theory that they said had been jealously guarded from ordinary people until the moment that they published it. This account appointed a supreme male Eeyore at the helm of creation, a being who willed everything, including Papa and Rangi, into existence. It also introduced the idea that Rangi and Papa reproduced 70 times without a single daughter. A truly fatuous notion when one pauses even for a moment to consider it. And it describes the beginning of the world in terms that mirror the first chapter of Genesis. Now, crucially, the so-called esoteric version explicitly removes the involvement of the female element at the point of creation. According to Best, Eeyore, the supreme being, had no progeny. He begat no form of being. He caused the earth and the heavenly bodies and the supernatural beings to come into being by means of his willpower. So it's clear that Eeyore has created the world without the female taint of any kind of birthing process. Whakapapa, which necessarily includes both female and male elements, is no longer foundational to creation, but is rendered secondary to the all-powerful, all-male creativity of Eeyore. Now, I want to be clear that it's not my intention to offend by singling out the Eeyore version of creation for criticism, nor is it for me to venture an opinion on whether or not some iwi have always included Eeyore in their creation kōrero. But what I will say is this: the strong parallels between Christianity and the particular variant of the Eeyore version proposed by Best and Smith cannot be denied, nor can its devastating impact on mana wāhine. As I've already noted, misogyny is a defining characteristic of any religion that begins with a supreme male god sitting at the apex of creation. Should also be pointed out that hierarchy looms large in the way that Elsden Best and Percy Smith categorised our creation narratives. They weren't content to let every iwi have its own creation narratives or to accept that each one was as valid as the next. They established a hierarchy of versions, the esoteric and the exoteric. The esoteric version, they claimed, had been kept secret from most of us because Eor's very name was too sacred for us even to be allowed to know about it. This version had been, according to Best, evolved by the higher minds among the natives, evidently by comparatively leisured men possessing remarkable powers of abstraction and introspective thought. On the other hand, the exoteric version, as he referred to it, this was what was shared with the common folk. This was the whakapapa-based narrative, which Best described as inferior, puerile, and grotesque. The concept of hierarchy is also threaded through their descriptions of our creation theories. The obsessive division of atua into categories is a case in point. So, for instance, after discussing Eor, Best moves on to describe the departmental gods, all male, before moving down the chain to third-class gods, who he describes as intermediate deities and tribal gods, and finally moving on to fourth-class gods, who he describes as deified ancestors and cacodemons, which is a new term for me. The use of categories was clearly a strategy for dealing with the complexity of Māori creation theories, because there's no doubt that monotheists struggled with that complexity. So creating categories was a way of creating order, I suppose, out of what they must have regarded as a dizzying proliferation of atua. There was another way that they tried to deal with complexity, which was simply to erase it altogether by creating uniformity where formerly there had been none. So in his 1963 Reid Book of Māori Mythology, for instance, Reid cheerfully admits that he has combined different tribal versions in order to create a satisfying composite picture. As Ross Cowman has since pointed out, the desire that Reid and earlier ethnographers had to create a single authentic version simply resulted in the creation of new hybrid stories, not the version of any one tribe, which have, in the course of time, taken on a life of their own. Needless to say, versions that challenged the sanctity of monogamy, such as those that spoke of rangi and papa having multiple relationships, tended to be glossed over. Versions that challenged heteronormativity, such as those describing both rangi and papa as giving birth, or suggesting that reproduction was possible as a result of relationships between two male atua, well, those versions just didn't make the cut. They were quickly buried. The influence of the early ethnographers on our thinking really cannot be underestimated. The so-called esoteric creation narrative was completely unknown until after the turn of the 20th century. In fact, Te Rangi Hiroa famously commented that Eor's discovery by Smith and Best had been a surprise to Māori and Pākehā alike. And yet, it has taken a remarkable hold. The extent of the hold it's taken, I find nothing short of extraordinary. Not all iwi have subscribed to it, but it has proven remarkably contagious. Quite apart from the dire messaging inherent in their Eor version, misogyny permeates the work of Best and Smith and others who followed. The way they describe our atua wāhine is always negative, at best dismissive, at worst degrading. Their work is the antithesis of mana wāhine. Best, for instance, concluded that in Māori myth and belief, the female sex is assigned an inferior position generally, and is primarily associated with evil, misfortune, and death. Now, because they published so prolifically, and no doubt because of their widely perceived status as experts, I should just tell you this, in 1924, Elsden Best was described as the greatest living authority on the Māori, as though there were no Māori alive at the time. So it just means that their work has just been accepted unquestioningly by generations of scholars. The impact on the status of Māori women has been substantial and devastating, even to the extent that comparatively recent work, which is clearly trying to redress the imbalance by making our atua wāhine more visible, ends up depicting them in patronising and demeaning terms. Take this, for example, this description of Hine Te Iwa Iwa, published in 2001 by the Ministry of Justice. They say this: Hine Te Iwa Iwa established the powers and responsibilities that women held in traditional times. She is the exemplary figure of a wife and mother, and as this, she provided the precedents for all women who follow. Now, this portrayal is a far cry indeed from the Hine Te Iwa Iwa that I discussed in my earlier brief. That Hine Te Iwa Iwa, as recounted by Te Rangi Haata, recited karakia while in the midst of a difficult labour, single-handedly summoning spiritual forces to facilitate the birth of her son. That Hine Te Iwa Iwa designed and implemented a complex and daring strategy to identify and then kidnap Kai out from under the very noses of his relatives. That Hine Te Iwa Iwa sought out and negotiated with whakatau to extract utu for the subsequent death of her son at the hands of Kai's people. That Hine Te Iwa Iwa was multifaceted. She was a tohunga, a creator, a consummate performer, a strategist, and a diplomat. And yet, by the time we get to the year 2001, and I would argue this is as a direct result of the toxic influence of Smith and Best and others of their ilk, by this time, Hine Te Iwa Iwa has been reduced to a nauseating caricature, representing some kind of idealised 1950s American sitcom wife and mother. It's little wonder that as a young woman, I felt no connection with Hine Te Iwa Iwa whatsoever. All I had ever heard about her was that she was the patron of womanly pursuits, making babies, busying herself with handicrafts, and priding herself on being the perfect hostess. So many years were to pass before I stumbled across Te Rangi Haata's riveting accounts of Hine Te Iwa Iwa and her achievements, and it was only then that I realised what I'd been missing out on. Okay, I'm turning now to the impact of colonial thought on tikanga and how that's impacted on the rangatiratanga of Wāhine Māori. I'm going for time. From the moment that missionaries began arriving here, our people came under immense pressure to conform to the colonisers' norms and expectations. Inevitably, our thinking was affected by missionary teachings, by the behaviour of Pākehā who came flooding into our land, and, after 1840, by the overbearing presence of colonial law. The work of early ethnographers played a key role in this process, erasing or significantly diminishing the presence of atua wāhine within our creation narratives. Predictably, our more recent female tūpuna suffered a similar fate, effectively written out of our iwi kōrero or reduced to shadows of their former selves. The kōrero about whakaotirangi and marama, I think, illustrates this point quite nicely. As a young person, I knew who Hoturoa was. His name sat in splendid isolation at the head of the top-down, linear and overwhelmingly male whakapapa chart that we were given to help us connect our marae and ourselves to the arrival of Tainui Waka in Aotearoa. I'd heard the names of various other waka captains too, all of them male, but I would have been hard-pressed to name a single woman who had come here on those waka. As I got older and became a bit more interested and wanted to find out a bit more, I learned a little more about whakaotirangi and marama. They were unerringly described first and foremost in terms of their relationship with Hoturoa. They were Hoturoa's wives. Whakaotirangi was the ageing one, the object of pity really, who Hoturoa left when he settled at Kāwhia in favour of marama, who was significantly younger, but who had sinned with a man and so was therefore not entirely to be trusted. Whakaotirangi eventually won back Hoturoa's affections by single-handedly cultivating the first ever crop of kumara in this unfamiliar environment, which, when you think about it, was clearly a pretty crucial contribution to the long-term survival of the people in this new land. Hoturoa, apparently impressed with this selfless act, and you have to think maybe getting worn out by running around after a much younger marama, returned to whakaotirangi. Marama, one imagines with a sigh of relief, promptly returned to Tāmaki and never looked back. Now, when you read the accounts, you can kind of glean that these two women had their own thing going on. They had their own talents. They were making their own contributions in their own way. But the point is that the story is never told from their point of view. They are described primarily in terms of their ability to win or lose favour with Hoturoa. Their key role is to add an element of interest to an otherwise male adventure. Turning to what happened at Otahuhu, most accounts make no mention of whakaotirangi whatsoever. You'd be forgiven for thinking she wasn't even there. And marama is only discussed insofar as she is suspected of having misbehaved with a man. It's this behaviour, unequivocally characterised as a transgression, that is blamed for the fact that the waka cannot be moved. There's no mention of the fact that she is the one who has deliberately fixed the waka in place through the use of karakia. And while it's confirmed that karakia are used to enable the waka to move again, no one ever says who recited the karakia. And given that when you look at the list of people who came on the waka, every person who is identified as a tohunga is a man, you would be forgiven for assuming that the person who recited the karakia on that occasion was a man. When it comes to our more recent history, the same pattern of erasure and diminution is there. Te Rauparaha, for instance, has captured the imagination of so many colonial writers, but Waitohi's name is virtually unknown outside of Ngāti Toa Rangatira and Ngāti Raukawa. While settler press and politicians regularly work themselves up into a hell of a state, trying to figure out what Te Rangi Haata and Te Rauparaha were thinking or doing, Rangi Topi Ora barely rated a mention. Insofar as Rangi Topi Ora has attracted the attention of Pākehā commentators through the ages, she's typically been written about as though she was some kind of exception to the rule being that only men exercised authority. I have one more really graphic illustration of the extent to which I think Ngāti Raukawa absorbed colonial thinking about the role of women, and it's in what occurred with the opening of the Tupuna Whare Raukawa in Otaki in 1936. The whare had been rebuilt over a 5-year period, strongly supported by Sir Apirana Ngata as part of his drive to revitalise te reo Māori and traditional Māori arts throughout the country. Te arawa carvers from the School of Māori Art had been brought in to help with the work, and the whare was opened by King Koroki. During the months leading up to the opening, controversy erupted, and the controversy concerned the pare, which depicted a kuia, parenga ope, and I'm quoting here, with her organs exposed in exaggerated fashion. Ngata reported that all of the Ngāti Raukawa elders, supported by Waikato, opposed the idea of the Māori king demeaning himself by passing under such a figure. Now, I just have to pause here to note the irony, because parenga ope was Potatau Te Wherowhero's mother. So she had quite literally given birth to the kingitanga from between her legs. But somehow it was demeaning for her mokopuna to walk beneath her. So my elders, supported by Waikato, felt that the offending carving should be removed. But the carvers, builders and architects insisted that doing that would invite disaster, because it would be to breach the carving tapu. It sounds as though a real stalemate ensued. They were arguing backwards and forwards for months, and it wasn't resolved until literally the night before the whare was opened, and it was resolved by Tā Apirana Ngata. He wrote to his friend Te Rangi Hiroa about this incident, and he wrote the following. The night before the day fixed for the ceremony, the opposition broke down. I told them of similar pare all over the world, preserved in many museums, of the convention relating to this feature of carved houses, of the custom which required that a female be the first to cross the pai poto under the pare, where she was required to smear her hand with the wai of her own hika, and to besmear in turn with the same wai the undersurface of the pare. Who were we to set up new fashions these days when the great ones of the past felt no whakaheke tupu in similar circumstances? So he won the day. Parenga ope, I'm pleased to say, is still there, resplendent, over the door of the Tupuna Whare Raukawa. But when I think about it, the apparent aversion of Ngāti Raukawa towards this expression of mana wāhine is such a far cry from Te Rauparaha's celebration of it, which I described in my earlier brief. You may recall that I spoke there about two of his particularly well-known compositions, He Oranga Nei and Ki Kiki Kākaka. And I argued there that these compositions clearly demonstrate Te Rauparaha's understanding of the significance of the birth canal as a conduit between Te Ao Marama and Te Pō, In the case of Kikiki Kākaka, he had hidden from his enemies by crouching inside the kumara pit while Te Rangi Koaia straddled the mouth of the pit, enabling him to be metaphorically reborn from Te Pō to Te Ao Marama as he climbed out of the pit once his pursuers had moved on. Now, there's no suggestion whatsoever that he felt in any way demeaned by this. On the contrary, he saw fit to commemorate the incidents as a triumph, a snatching of life from the jaws of death, no less. Nor is there any hint that he is feeling some kind of squeamishness with respect to the vulva poised directly above him. The words of his ngeri refers to it explicitly, willing it to remain impenetrable to the karakia that were being recited by his pursuers for the purpose of seeking him out. The fact that we've become so disconnected from our own tikanga by the 1930s is no accident. It's the result of nearly a century of careful reprogramming by the church and the constant misrepresentation of our tikanga by those who claimed to know more about us than we knew ourselves. Writing about this event in his biography of Sir Apirana Ngata, Ranginui rightly describes this event as symptomatic of the break with the past brought on by Christianity and colonisation. Now, I wish I could report that Ngata's intervention on this occasion caused Ngāti Raukua to rethink the concepts of patriarchy and misogyny that had so clearly made very disturbing inroads into our thinking by the 1930s. Anecdotally, however, it seems that what did live on in the memories of those who were caught up in the debate was the fact of the controversy and not the explanation that led to its resolution. So when my hapu rebuilt our tupuna whare in the 1970s, the carvers were very careful to put 3 male tupuna on the pare over the door, which might be an indication that we just had no appetite for a repeat performance of the controversy that had broken out when we opened Raukawa. The examples that I've recounted, from the telling of the story about whakaotirangi and marama, to the way that Waitohi and Rangitope Ora are remembered, to these more recent events concerning the way that women are represented in our tupuna whare. These clearly reveal, I think, the impact of colonial thought on our tikanga, particularly on tikanga that demonstrate the distinctive mana of women. Now, I'm not suggesting that women did not continue to exercise authority, but this certainly affected the way that authority was expressed and described. So within my own hapu, there are numerous strong women, but they tended to toil away quietly and without fuss, couching their contributions to hapu activity primarily in terms of their obligation to support the menfolk. They also counselled us on the multitude of things that as girls we should avoid at all costs. We should avoid sitting on the wrong seats. We should avoid stepping over boys or men, leaving items of clothing in the wrong place, or even touching items of clothing belonging to men. Really importantly, these words of caution were never once accompanied by the explanation that the whare tangata made us powerful and that with power comes responsibility. We were left to figure out the reasons as best we could. It was hard to imagine that to be a woman was to be a person of mana, particularly when we compared the seemingly endless restrictions on what we could do with the apparent freedom of our male contemporaries. Now, I want to be clear, no one ever told me that I was less important than my male relatives, but the subliminal and sometimes not so subliminal messages were pretty hard to miss. I grew up well aware, for example, that my father was pitied for having 4 daughters and no sons. Such a shame, people would come up and say to my mother, with no hint of shame at their own extraordinary rudeness. My mother, feisty and fiercely intelligent, endured 4 extraordinarily difficult pregnancies to have the 4 of us. Years later, I asked her, why did you keep trying? And the answer was shocking to me in its clarity. She had kept trying because they were trying for a boy. I'm really ashamed to admit it now, but when I produced a son, I could not help but feel relieved, knowing that I would not be forced to endure a lifetime of snide innuendos about having let my husband down. One of my aunties clearly felt the same sense of relief on my behalf, simply pronouncing the appearance of my son as a miracle. When I reflect on the messaging that prevailed about the relative value of girls and boys, the The impact of colonial thinking on our perceptions of normality is plain to see. There was no escaping the fact that as girls, we were somehow less than, not unimportant, because we had contributions to make, contributions that were both encouraged and acknowledged. But given the constant flow of cautionary advice on what we could and couldn't do and how we should do it, I, for one, always felt that the quality of whatever we contributed would be measured by the extent to which we knew our place. This messaging, of course, was reinforced at every turn by the virtual invisibility of Atua Wāhine in every readily available account of our creation narratives, by the fact that no one even paused to question the likelihood of a couple producing 70 sons, no one even thinking to ask why all the main players in the story of creation were male, was driven home by the fact that our male tupuna occupied centre stage in our iwi history, our kuia largely being relegated to the status of background props, aside from the occasional fleeting moment in the spotlight. Now, there were, of course, instances where the contribution of women was acknowledged, but never so loudly or as frequently as that of the men. We mirrored Pākehā fixations on our male tupuna. We heard much more about the role played by Te Rauparaha and other male rangatira in the migration of Ngāti Raukua to the Kapiti Coast than we ever heard about Waitohi. The way her tono to our Ngāti Huia tupuna was described is also really interesting. Her use of the word were were was typically euphemised to simply mean relatives or heirs of my body. But our history records very clearly that her use of the word were were, meaning pubic hairs, had been the deciding factor. Our old people will say it was the use of her word, it was her use of that word that made them change their minds and come. My uncle told me that. But by the 20th century, such language was clearly considered indelicate. So, over a century of Christian influence and the colonial retelling of our stories had now left an indelible impression on the stories that we now told about ourselves. Okay, so I've just got a few concluding remarks to make now. Firstly, this submission, as you will have noticed, is primarily focused on Ngāti Raukua. That's partly because you're always safest to talk about yourself. But I would be surprised if much of what I have said does not strike a chord of recognition for others. This is partly due to the fact that there are so many key themes that our creation narratives have that are common with the kōrero from other iwi, the centrality of whakapapa being the most important one, I think. And this commonality of key themes has translated into tikanga that reaffirmed the mana of Wāhine throughout many, if not all, iwi, not just my own. Secondly, it's because the experience of colonisation has been much the same for one iwi as it has been for the next. The truth is that European imperialists were never a particularly innovative bunch. They generally worked from the same colonial script wherever they went in the world. They made adjustments over time, perfecting their heinous art as they spread out across the globe in search of colonial spoils, but the core approach remained the same. We know this because of the striking similarities in experience as between ourselves and our Indigenous brothers and sisters in other parts of the world. The second thing I would say is that this submission has not explicitly addressed the manifestation of patriarchy through the structures and processes of colonial law. The Crown response to expressions of mana wāhine can be seen clearly enough in the way the missionaries attempted to prevent Te Rangi Topeora from signing Te Treaty o Waitangi and Otaki. They were unsuccessful, Rangi Topeora pushing her way forward to sign in her own right as a rangatira of both her iwi. But the pattern of privileging Māori men over Māori women within its law and processes was to continue apace as the colonial state extended its reach into all aspects of our lives. The colonial state's law was simply another expression of the same twisted view of the world that informed the actions of all agents of colonisation, from missionary to surveyor storyteller, from rapacious settler to grasping Crown official. The principle of hierarchy, expressed through racism and misogyny, lies at the root of all that has been done in the name of colonisation. The primary focus of this submission has been the spawn of hierarchy and misogyny, patriarchy. In particular, I have sought to illustrate what patriarchy has done to the way we think and behave. Because to me, the true evil of colonisation is not just what they did to us, It lies in the way that they programmed us to do it to ourselves. By driving a wedge between the two key elements in whakapapa, female and male, patriarchy functions to destabilise whānau, hapu and iwi, encouraging us to turn on ourselves and undermining our resistance to the forces that were gathered against us. To me, the mana wāhine claim represents a crucial step in pushing back against the colonial thinking that has weakened us to our core. It is a call to action. It reminds us that we must first repair the most intimate whakapapa relationships if we are to have any hope of restoring te tino rangatiratanga. Tēnā koutou katoa.
Well, tēnā koe, Annie, for your evidence this afternoon. There is some pātai from the panel. So I'll just check. Linda, are you going to have any pātai for Annie?
No, I have a comment though. E mihi ana e Annie.
Kia ora.
The sound is beautiful, and listening to you for me this afternoon has been just compelling. Thank you for all the examples and stories.
Kia ora.
Kia ora.
Tēnā koe ani ki e rā kōrero. He pēnei tonu I tētahi wānanga kare pirangi kia mutu I reira. E pirangi anau kia kotahi rau pātai ki a koe, ka tahi pēr ka ea te whakaaro I roto I au. Ki au nei, kua kite atu te hua o te wānanga, kua noho ia e koe I roto I ngā tau. Kua āta ruku atu koe ki ngā puna kōrero e hia kēnei. He whānui te titiro, he maha ngā tauira, tautoko I te kōrero a tuhiwai ana I aia e mea ana ki katoa I etahi tauira e tae e mātou I te whakamahi. Ko tētahi o ngā kōrero, kei roto I a mātou I pariaka ko tō mātou urupā ko werewere, te werewere, te ingoa o te urupā. Ana ke mōhio nau, he rite nei te tikanga. Engari nāia nei, ko kaha te kōrero weriweri nā te mea kāri te pirangi ki tino whakamahi I tērā momo whakamārama. Nō reira, he whakaaro nui nōku ki tērā. Ko tētahi o aku pātai, tērā pēr he paitonu kia waiho kia whakairi atu ki runga I a koe, mehe mea pirangi ana kia whakautu a muri atu kei te pai. Ko tētahi mea I roto I au e whakaaro atu ana ki te mana wahine, te mana wāhine. Ko I te mea ka ki atu mana wahine kei te kōrero mō ngā āhuatanga katoa o te wahine, ne? Mana wāhine kei te kōrero mō ngā wāhine nei, ngā tupuna, e pēhea nei e ra whakaaro. Mehe mea ka ki he rereke e tērā te mana wahine I te mana wāhine, ko tehea te kei te tika, ko rāua tahi rā nei e tika ana. Mehe mea ko rāua tahi e tika ana, tērā no pēr mea ata whakaaro atu mātou I a mātou e tuhi ana I tō mātou pūrongo, kia tino hāngai tika, ki ngā momo whakaaro pēr pēnei I ngā kōrero kua puta I a koe, mehe mea ka he I reira, ka he katoa pēr te ahu o te pūrongo I te mea koera te ingoa o tēnei kaupapa. He whakaaro o e pana.
He tino pātai tēnā, tino pātai. Me tūpea he wānanga pirangi ana hau ki te haere ki tērā wānanga. Ko te tihi kāre tino mōhio mehe mea mana wāhine rānei. Nō reira, he pātai pai. Kāre kautaku whakautu.
Kei te pai noi ho tērā no pēr he wānanga he haramai ana ki I runga I tērā kaupapa. Ko tētahi anō, I rongo atu au I te kōrero a Miss Sykes, e mea ana, me te tika katoa o ana kōrero whakamanawa I a koe, I te mea he pērā ia wā kua tū koe ki mua I a mātou he kounga katoa ngā kōrero I roto. Ko tētahi wana kōrero ko te wewete I te tino rangatiratanga me te mana motuhake. Nā, kia au nei, kāre he mutunga o tērā momo wewete, engari i roto i a mana wāhine rane, engari ko tēnei mea i te nuinga o ngā wā ka whakaaro atu tātou te tino rangatiratanga kei te kōrero mo te iwi Māori te karauna, ne?
Ai.
Engari, i runga no i te ia o kōrero, ko te tino rangatiratanga, e tika ana te tino rangatiratanga o mana wahine ko te rangatiratanga rānei. Me he mea kei te kōrero rā mō mana tāne mana wahine, he tika ana te tino i reira, kei te wewete atu au i tērā kupu tino, e te tuarua ko te kupu mana motuhake, kia kau e whakaaro atu ko te motuhake he separate, engari he pai kē ko te whakaaro atu pēnei te kupu distinct. Nō reira, kāreo i te pirangi kia timata te whakaaro ki enei momo mātātika e principles nei e whakawhāiti mai ki e tahi kupu, engari e pirangi ana au, kia tuhia etahi o enei kōrero i roto i te reo Māori, kei te pirangi kia mārama ngā kupu e whakamahi ana, ana ko ngā momo pēnei i a koe, ki au nei, kua roa e wānanga nei enei take, ko koutou ngā mea e tikana ki te whakautu, ki te wānanga, ki te arataki rānei, i enei momo whāinga. Ne?
Au e. Well, ko taua whakautu anō, me he mea ka tū tētahi wānanga, ko au tērā he tere haere atu ki taua wānanga, ria pai, tino pai.
Ko te mea nui nei, kua kite atu i tō wānanga nei, i ngā karakia, i ngā kōrero, te āhua nei, i puta i te wānanga, tēnā no me wānanga pēr i aua take. Bueno, tēnā koe.
Kia ora.
Tēnā.
Oh. Hara mai ki mua, koe? Hara mai, te ripu ai, hara mai ki te taha o te hotunoro. Kāre te hinga i te rongo i tō rea. E kore kā te whakahei tēnei, nā ringi te mea nōna te whare. Nō reira kōrero.
I tipu mai a mewa kukui, nā taku kuia me taku kurau a te taha taku māma mātau i whāngai. Ana, kia rātau, he mana tō te tangata aha koa kowai. He mana tō tēnā. Kāri rere ke ake mai tētahi. Kamutu, kaua koe patu i te mana o tētahi atu. Koe rau whakarana. He a tātou kororo nei mo te mana o te tangata. He mana tō tēnā. Ko hau te mātāmua tō mātai whānau ana. Moe ai au i te rūma me taku kuia me taku koroua. Ana, ka me ana kua taki wānanga, kai te whakarongo atu au e taki wānanga ana. Ana, koe rai e tahi onga, i pātai atau, hea te mana motu hake. He rere ke te rau mai te, he mana tō te tangata aha koa kowai. Ka mutu me pai tō ngā kau ki te tangata. Nā te mea he mana tōna. Pura noi. Kare moho pēnā, kua pai ake, kua mārama ake.
Tēnā koe whaia.
Tēnā koe, Ms. Makaira. I'm assuming you haven't been made a dame yet, but...
I think you can safely assume I never will be.
I was struck by your description of self-appointed experts, and I don't want to go ahead to the whenua pou, but I was wondering whether you had thoughts you'd like to share about Crown-appointed experts, the Native Land Court judges, not so much in terms of the titles they're awarding, but in terms of how they are interpreting tikanga.
Oh, you're talking about now?
No, I'm talking about historically.
Oh, sorry. That was a genuine question.
I wouldn't dare.
Yeah, fuel, because probably not I. Yeah, I mean, I think the whole concept of who is an expert and where they get their mandate from to be an expert is always problematic, right? So I find it hard to believe that anyone who the Crown appointed in historical times as an expert was in fact an expert. Someone may find an example to prove me wrong. I haven't yet come across one. Does that answer you?
And do you have any comments about how they're interpreting custom?
Can you give me something more concrete? I'm just struggling to think.
Things like conquest, for example.
Oh yeah. No, I think 9 times out of 10 they get it wrong. They're far too black and white. They always miss the layers or the complexity or they often miss the really key things that our tupuna get, but I don't think they did. Yeah, they were very, very either or in a lot of ways that they thought, yeah.
And do you think that process and putting kōrero into that forum had an effect on women's role as keepers of knowledge and whakapapa?
Yeah, for sure. Absolutely. I mean, the written word probably did too, and who had access to publishing. You know, one of the reasons why Best and Smith are experts is because they just publish so prolifically, and once something is fixed in concrete, it just kind of takes on. Actually, I remember your dad, Sir Paul Reeves, talking about that once something is written, it's fixed and you can't change it, and it takes on a life of its own. You know, we have to be careful of that too, incidentally. Yeah.
And that affects how Māori are interpreting their
Absolutely.
own history.
When I first went to Te Wānanga, which is where I work, we had a library, and it probably still is, but so much of the stuff that we relied upon to learn about ourselves had been published by these men, because they're the ones who'd had the luxury to publish. That's one of many reasons why we have to do everything we can to publish, because it was all a one-sided story and 90% of it was wrong, in my view. You know, there were snippets of things that were correct, but they always put them together in the wrong way and came up with the wrong answer. Yeah.
All right, well, thank you very much. A very interesting brief of
Kia ora.
evidence, and I hope you come back and give some more evidence in the future.
In asking the question that I'm about to ask you, I'm very aware that we are at the very beginning of this part of the inquiry, and that the evidence that you have given us today is foundational evidence around the thinking and philosophy and those in that space. But of course, as the presiding officer in this inquiry, I can't help myself. I'm thinking down the track, and at some point in time, we're going to have to wrestle all of this, and we're going to have to produce a report. And in order to do that, we're going to need to make some findings. We're going to need to make findings about Crown actions and breaches of te tiriti. So in considering the evidence that you've given us today, which is really mapping out for us the impact of colonial thought or philosophy, which sits behind the colonial project, for want of a different phrase. At what point do you consider, or can you indicate, are we starting to see the types of key Crown actions that we might be able to identify as in our as Crown breaches? Do you understand what I'm...
No, sorry, could you
sorry.
just rephrase that?
Yeah. So we're talking, you've given us an account of of the philosophical underpinnings, on certainly the impact on the creation theories. We've talked about Best and Smith and the influence that their writings have had. And then we move through into the impact of that kind of thinking and writing on tikanga and rangatiratanga. At what point do you believe we are starting to see or identify concrete Crown actions that we could identify with this hat on as being in breach?
Well, it started from the moment the Crown set foot on our shores, really. I mean, there are lots about the ways that they went about getting people to sign Te Treaty that I think were clear breaches of tikanga in terms of our women having authority, political authority. So we know that they tried to block Rangi Topiora, but she wasn't someone you blocked with ease. But there are other stories about other women. I know Moana Jackson would talk about his hapu. They had a woman who was designated to sign on their behalf. I hope I'm getting this right. He told the story many times. And the people who turned up with the treaty wouldn't let her sign, so his entire hapu walked. And I don't think that was the only example. There are other examples around. The more we talk, I think the more of these examples come forward. So right from that moment, really, and then every piece of law they ever passed had misogyny threaded through it. They couldn't help it. I'm not even saying these were bad guys, they just couldn't help what they were and what they were a product of. So everything they did, I would say probably every law they ever passed, you'd be able to find something in there that we could point to and say, no, it's a breach. Some things obviously more than others. A lot of the land legislation, how they determined who could succeed to land, who could have title to land, all of that stuff. And I know you're going to get lots of examples of that, which from people who know much more than I do, but the political representation, everything. The kōrero from the Māori Women's Welfare League about how at some point the government created the New Zealand Māori Council and preferred them to listening to the Māori Women's Welfare League, so that's a more recent example. But there are so many examples that you couldn't even hope to capture them all. But I guess what you'll probably end up doing is getting a selection from perhaps different time periods to show. What is important is that we don't just say this happened back in the far distant past. The point is that it is replicated in the present and it will be replicated in the future unless we break that cycle. That's the really important thing. So whatever this tribunal can do to contribute to breaking that cycle, I think will be a massive contribution.
Okay. Now, I'm aware, and Ms. Sykes, we had an exchange about it earlier about the questions of clarification that have been provided. So we have received some questions. I don't know whether you've had an opportunity to review any of that.
At the last minute I didn't get them until very late last night. So.
Yeah, that's absolutely fine. I mean, I think the way in which the timeframes, for the filing of evidence and everything, with the layers of busyness that everyone has had in the last couple of months has meant that the timeframes just got pretty short. So I think probably the way we're likely to deal with that, Ms. Dean, is by timetabling written answers to be provided. That's a process that we followed previously, and I think it means that you get a pretty comprehensive response.
Thank you. If I could just briefly address that. The only point I'd make in addition is that we have written questions and writing timetable to follow, and so if there was the filing of written answers to questions of clarification, the time frame for the questions and writing would need to be pushed out to follow that. And the tribunal, you just need to consider what worked for your time frames. But any comment? Kia ora.
Well, I mean, at this point, we don't have any dates for our next hearing. So it may be that there's going to be sufficient time for everything to catch up. So I'm sure that can be managed in a way which is fair and gives sufficient time for those responses to be given. I think those are all the questions that we have for you, Annie.
Kia ora.
And again, I just want to thank you very much for, I mean, thoughtful doesn't even sort of begin to describe, you know, the nature of the evidence that you are giving to us, and, you know, it's foundational in its nature, and it really helps us to ground these claims, and the layers of evidence as they're being built will be built on a firm foundation. So,
Kia ora.
Ngā mihi kia.
Tēnā koutou.
Ma'am, with the tribunal's leave, I would ask if we could put her thesis on the record. It's I haven't filed it yet, but I found it absolutely inspiring. I only recently gotten access to it. I have to seek her permission for that. We have other works of Annie on the record,
yes,
but this one isn't on the record. So if you could reflect on that in the afternoon adjournment, I'll try and get us express permission for her.
So, is the balance destroyed on the record?
It was certainly filed, if not by us, by someone else during the kōrero tuku iho phase. Okay. But I'll make sure it is under the author's name.
All right. Okay. Thank you. Well, how are we doing? All right. We have 10 minutes until kaputi. What is the... so we have some time for only 10 minutes for our next witness before we're due to break. What's your preference at this point?
Well, just by way of explanation, Mum, we're sort of going to be popping up differently for different witnesses, so there'll be different counsel leading different witnesses, and Miss Mora will lead our next witness. But we think, similar to Ms Sykes, we'd like to just do an introduction, sort of leading in to Ms Reid's evidence, and then perhaps after afternoon tea,
yeah, okay,
she can jump up and give give her presentation, of which there is a PowerPoint associated. So we'll get that set up during the break.
Yep, kapai. I agree with that. It's weird to start and then go, okay, we've got to stop now. So, kei a koe.
Tēnā koe, te kai whakawā, tēnā koutou i te rōpū whakamana i te tiriti. Nō ngā hau o te tai tokerau, i te uri o te rarawa o te au pauri hoki, tēnā koe. E taku rangatira e mihi kau ana ki a koe no mātou te wai Māori e ki te rongo i o kōrero taunaki mō te kaupapa whakahirahira nei, ara mō te kreme wai 381. Ko tēnei tuahine, he ahorangi, he tākuta, he kai whakaora tangata, he mana wahine. Tākuta Paparangi Reid is a descendant of Te Rarawa and Te Ao Pauri. She is a professor, a doctor, a health practitioner, and a mana wahine in her own right. Her portfolio of research spans 30 years, analysing disparities between Māori and non-Māori as a means of monitoring the Crown's commitment to Māori rights, or as she is so often put, the Crown's inaction. She is extensively published in this area and has led campaigns on anti-smoking, cervical cancer, and exploring the causal pathway of high Māori mortality rates. In addition, she has demonstrated extraordinary leadership in developing the Māori health and research workforce. From being one of the only Māori students in her university course, she inspires and continues to inspire emerging Māori health leaders and workers through health education and training. Paparangi is known for her distinct decolonial methodology when it comes to analysing the causal pathways that lead to Māori health inequities, of which are grounded in racist, colonial and patriarchal forces that continue to operate today, and her evidence will speak to those forces. Much of her thinking was inspired by her involvement when she was a junior Māori doctor in a number of Māori political movements, This included the Black Women's Movement alongside other claimants such as Ripeke Evans and Donna Awatere Huata. Against that background, and after the break, we will call Professor Dr. Paparangi Reid to present her evidence to the tribunal. And just for the tribunal's reference, her brief of evidence is on the record of inquiry at Appellation C7. Tēnā koutou katoa.
Tēnā koe, thank you for that. We will now adjourn for afternoon break, and we will be back at 3:30 to hear from Dr. Reid. Tēnā tātou. Tēnā koe tāku to read. Kei a koe te mana.
E rere ana ngā mihi aroha ki ngā mana wāhine, ko wehe atu ki te pō. Rātau, ngā kai hautu o tēnei kaupapa i whakarangatira i a mātou, ngā kanohi ora hei kawe i tēnei kireme. Anō hoki ki ngā tini mati, kei wainga nui a tātou, haere. Ko Robin Kahukiwa tērā, ko Hini Whare Haroira tērā, ko Tare ana Tūria tērā, me mihi ka tika. Ki ngā mana whenua o tēnei rohe, tēnā koutou. Ki te haukainga o te marae nei, tēnā koutou. Kia tātou, ko hui hui mai nei, ki te kai whakawā, tēnā koe, ngā mema o te tribunal, tēnā koutou. Kia koutou o tērā taha, kia tātou tēnei taha, tēnā koutou, tēnā koutou. Tēnei he uri o hokianga nui a kupe e mihi ana. Ko te rarawa te iwi, tau māui te hapu. Ko te ākau te moana, ko tara keha te maunga, ko tinana te waka, ko mā tihi te marae, no miti miti ahau. Nō reira, ko Pāpārangi Reid, tōku ingoa. I've submitted a brief of evidence, but I'm going to
summarise and highlight different parts of the evidence, and I've got some PowerPoint slides which I hope will illustrate some of the complexities I was trying to communicate. The legal team has kindly noted some of my background, especially my background in health and my qualifications to speak on Māori health and especially on health equity. I'm a public health physician, and I'm a specialist in public health, and I'm a professor of Māori health at the University of Auckland. During the time that I was working to become a specialist, I worked in a number of research projects and health policy placements, especially with the late Professor Iru Pōmari, who had at that time begun the Hauora series, a series of research projects comparing health outcomes of Māori compared to non-Māori citizens. It was a really interesting time for me, and it has been the basis of much of my research work, focusing on health equity and health inequities. To get really involved in this research, you have to have an understanding of several different things. You have to have a theoretical standpoint, and I want to acknowledge Professor Linda Tuhiwai-Smith, who was formative in those of us working at the Iru Pōmari Centre to engage with kaupapa Māori theory and epidemiology. We also had to have understandings of data quality issues, and we found oftentimes Māori were not being counted in official data sets, and that is another form of being ignored and being undermined. We had to have an understanding of what are health inequities, and we went through a period of defining health inequities and health equity, and I'll touch on that in a minute. And then we went through a period of working out what were the causal pathways, because oftentimes we were being accused of, we were being victim blamed in terms of our own health outcomes, instead of looking at the structures and systems and intervention points that we should have been looking at. So I want to talk a little bit about health inequity and the definition of equity in health. And equity and inequity is really now well described in the literature as differences in health outcomes that are unfair and unjust. And I want to talk about the difference between equity and equality. And so inequality just means things that are different. And as an example, perhaps we could say men don't get cervical cancer and women do, and that's an inequality, but it's not an inequity. It's not unfair because men don't have cervixes. Likewise, women don't get prostate cancer. In another example, perhaps both men and women get breast cancer, but only screening is offered to women to try and identify breast cancer early, because women have much different rates of breast cancer. So these are inequalities, but they're not unfair or unjust. And so therefore they're not inequities. In the literature, Braverman and Gruskin, they said, where should we put the bar for what's unjust and unfair? And they said that inequities, we should base equity on the highest standard of health for a nation should be interpreted as the health status enjoyed by the most privileged. So the health, in some ways, the health status of non-Māori women is the status that we should all be aiming for at the very least, and what our government should be trying to attain for us. And this is in the international literature, it's not about New Zealand. Equity became such a big thing in the early part of this century that the WHO had a commission on the social determinants of health that operated between 2005 and 2008. And they noted that the conditions in which people live and die are in turn shaped by political, social, and economic forces. And the development of a society, rich or poor, can be judged on the quality of its population health and how fairly health is distributed across the social spectrum and the degree of protection provided from disadvantage as a result of ill health. So there's a lot of high-level international focus on equity as a just part of health outcomes. Okay, I'm going to go to a slide. Oh, it's probably the next one. Yep, after I did that. Okay. So I want to talk a little bit about causal pathways. So interesting this morning in the opening statements, thinking about, and especially the Crown opening statement, talking about how they acknowledged various aspects of tribunal work. It had already acknowledged that breaches, including historical processes, but actually the historical processes were also part of a causal pathway that led to the differences in the social determinants of health and there's other parts of the pathway. So I'll just talk about that briefly. In this basic causal pathway that I teach to stage 1 students, and it comes from a United States epidemiologist and Dr. Kamara Jones, who spent a year in New Zealand on an Ian Axford Fellowship. And she writes that ethnic inequities in health are derived from differential access to the social determinants of health, differential access to and through health services, and differential quality of the care received. There is ample evidence for these 3 points, both here in Aotearoa and also internationally. So those three top parts, right down to the differences in quality of care received, are well exampled here in Aotearoa. So the social determinants of health include housing, education, wealth, income, etc. And so we can understand how the tribunal findings on historical processes, whether they be land alienation, or whether they be marginalisation through schooling, taking of language, etc., the diminution of culture have had an impact on who has access to the social determinants of health, who has differences in health, housing, who has differences in living in deprived neighbourhoods. All these things are not accidental. They are the outcome of a differential access to the goods, services and opportunities of society. Likewise, our access to and through health services is shaped by a number of factors, including institutional racism. In part 1 of the Hauora claim, the then Director General of Health, now Sir Ashley Bloomfield, he did admit that the health sector showed evidence of institutional racism. And that's also followed through the differences in quality of care received. There has been long-standing evidence from Aotearoa, New Zealand and other places overseas that we experience a different health care system. We are less likely to be referred for investigations. We're less likely to be have all our questions answered. We're less likely to receive the most modern medications for our illness, etc., etc. So there's amazing amount of evidence that we receive a different quality of care when we encounter the health system. And it's mirrored overseas. The Institute of Medicine produced a major report 15 years ago called the Quality Chasm. And these all have an impact on health outcomes. So our health inequities, we should never feel victim blamed, or we should never be victim blamed about our health inequities. They are shaped by systematic and structural factors. So I want to make sure that we absolutely get that our health is structured, our health outcomes are structured from systematic and structural factors, and that the inputting into those structural factors, causing some of the wobble, if not a lot of the wobble, is the historic processes that the tribunal has already spent much of its lifetime looking at. And following on from Ani's kōrero, what is driving that cycle is actually the racism that's built into our society from coloniality, the differences in the accepted humanity of Māori. The fact that it is the pattern is the same with Indigenous people from Australia, from Hawaii, from North America, from Canada, from parts of South America. The evidence is the same. So I want to look at another slide now. Just in case you thought stage 1 was too babyish, this is another one that's a bit more complex. And this is another US researcher in this space, Professor David Williams. And he writes that the causal pathway here, he's included racism and privilege in the causal pathway. And using his work, and if you just look at the top line, he goes, he wants, all our responses are often surface causes. So when we want to change health, improve health, we focus on responses or surface causes, and we never get down to the basic causes. And he writes that we should start focusing on interventions on basic causes. So using his work, a team in our department modified this model for settler colonial societies, and this is the modified Williams model that I'm showing you here. And this is what we teach to stage 2 students, so that we want them to learn about the basic causes. We want them to learn how basic causes and how values like racism and privilege affect health outcomes. And I provide you with this information and further references, in part because the Crown submission that evidence is needed to be supplied to support allegations of breaches. The next thing I want to focus on, and I'll ask for a slide in a minute, is the willful disregard for Māori needs and rights. The current coalition government has moved away from equity to equality, and that's a dangerous move for Māori health and for women's well-being. And one current example is the bowel screening program. So maybe we'll look at the next slide. Colorectal cancer is a significant cancer in Aotearoa, New Zealand. When I was a medical student, junior doctor, it was very uncommon amongst Māori. But now it's a significant cancer among both Māori and non-Māori. The purpose of bowel screening is to detect cancers at an early stage, where many, most or more, are treatable. Screening programs try to balance the appropriate age to start screening. As you can see from this graph, Māori in the orange, red, get bowel cancer, are more likely to get bowel cancer at an earlier age, and peaking around, I don't know, is that 55 or something like that. Whereas non-Māori in the blue are more likely to get bowel cancer or to be diagnosed with bowel cancer about 10 years later. The initial screening age for bowel cancer screening was set at 60 to 74 years of age, and the rollout was starting in 2017, slowly but surely. You can see from this figure that, as I said before, Māori get colorectal cancer earlier, so a universal one-size-fits-all will be unfair and unjust, and therefore inequitable. In 2021, Māori colleagues lobbied for an earlier start to screening for Māori and Pacific in order to have equitable chances of early detection. This was eventually accepted, and the policy changed with a rollout set to begin. Maybe we can look at the next slide. So does that make sense? Can you see that we need a different screening age? Yeah. Okay, the next slide, figure 2. So we lobbied for a 10-year earlier starting screening for Māori and Pacific, because as you can see, if we want to get, in the blue line, we can see at age 60, we get about 27 to 29% of cancer pickup. So we're picking up 30. So in the 15 years that follow, we're going to pick up a lot more cancers at an early age. If we start at 60, already about 60% of cancers for Māori women will be detected, or otherwise late detected, or people will die, have already died from them, and slightly less for Māori men. So that if we wanted to be equivalent, equitable for Māori and non-Māori, we needed to start screening at the age of 50 to get a similar proportion and a similar proportion of early detection. Hope that makes sense. Okay, so we lobbied, my colleagues lobbied, and we got an earlier start agreed to for Māori and Pacific in order to have equitable chances of early detection. And a rollout was due to begin. The recent policy decision by the current government overturned that decision and used the money set aside for the equity rollout to change the screening age for everyone to 58, which means that for some New Zealanders, mainly Pākehā, they would get detected earlier. However, there will still be a gross inequity for Māori. They called the age extension for Māori racist when actually it was equitable. The tribunal has already commented recently in Haumaru and Hautupua how political decisions don't negate Crown Treaty obligations. And I'll read you some words from the findings. In Haumaru, the tribunal noted, the Crown has a treaty duty to adopt rational, scientific, equitable policy choices for Māori. It has a moral and ethical duty to defend them against unreasonable public backlash. It cannot simply find ways of avoiding these duties by coming up with less equitable alternatives. It must make those choices that sustain Māori well-being and then explain and defend them as long as and as vocally as required. Failing to perform these duties for the sake of political convenience does not reflect the treaty partnership and in fact threatens the fundamental basis of it. In Hautupua, Tiriti duties must be honoured in spite of political ideology. The Crown cannot avoid its tiriti obligations at will, nor can it justify such avoidance because of political mandate. The tiriti applies to Crown and its functions, whoever is exercising them and however they came to power. So I just want to reiterate that one of the things I was asked in the questions from the Crown was the findings already from the tribunal and why are we presenting health again in this claim. And, you know, possibly rather sadly at times, and maybe this is one of the times, that because the tribunal has already made very significant findings on breaches and recommendations with respect to health, however, these have not been acted on by subsequent Crown actions, and sadly, one of the functions of claims to the tribunal is to document, at the very least, these actions. So documenting breaches, documenting further breaches, is the very least we can hope for in making claims to the tribunal. So life-saving, life-lengthening interventions such as this lowered age extension are evidence-based, thoroughly reviewed, and best practice. So changes to these policies must be seen as deliberate, ignorant and ill-informed, knowing attempts to harm Māori. Inequities, you know, we get so used to them, we start thinking they're normal, we start half by just going, oh, yeah, oh gosh, that's the same as it was before. Oh, oh, it's a little bit better, it's not quite, we start normalising them, and I want us to reject that normalisation of inequities. I want us to see ourselves and our families in the data of dying prematurely like my father did, of having cancer spread like others we love did. In one of the opening hearings, Professor Leonie Pihama stated that we're not here to argue that Māori women have mana wahine, but rather that the Crown denied, denigrated and tried to destroy it. And so I haven't come here armed with lots of statistics that compare the health and well-being of Māori women with that of others. Although I could tell you that many of those statistics that I studied for Māori women 30-something years ago have not changed that much and are still inequitable, and challenges remain. In my brief of evidence, I talked about the difficulty in having brave discussions about Māori men and being part of the problem. And by this, I refer to the intersection of racism and sexism, and that we understood that to overcome and fight racism, we needed to partner with Māori men. Besides, they're our tupuna, our fathers, our brothers, our uncles, our cousins, our sons, our mokopuna, and we are bound to them with whakapapa. We cry when they die, we cry when they are injured, we cry when they face prejudice. We're angry, just as we are, and just as we cry for each other. This is not a competition with Māori men in respect of health and well-being. It's true, we needed more of them to understand sexism and not be seduced by white male privilege, but at the same time, the Crown was playing its divide and rule act. So this claim is against the Crown, against Crown action and inaction. It's not a claim against Pākehā, although our right to monitor the Crown as tangata whenua provides us with insight into white privilege and male privilege and how it's been constructed through colonial, racist, misogynist policies, processes and systems. Remediation of this claim won't only come from the kāwanatanga sphere, even if it's fair and just. It will also need to support the Māori right to tino rangatiratanga, or have we decided yet that it's mana motuhake, I'm not sure, especially the rights of Māori women. I'm interested in the rangatiratanga sphere because wasn't it interesting that we saw it during COVID, but wasn't it interesting this morning during the pōwhiri when there was a decision not to have hongi? And because we have a wave of COVID happening at the moment, and we've also got a wave of influenza that's happening, let alone all the viruses that kids can get. So I'm so interested that in this, we saw a rangatiratanga moment happening where we decided what's good for us, and we even changed kawa and tikana to work for that. So our rangatiratanga sphere is alive and well. Finally, I want to note that Māori women had to be resilient as a survival mechanism against racism and sexism, and these are hard-baked into this settler colonial society. But rather more than resilience, we see the cost of becoming resilient. And what we really need is freedom from interlocking systems of oppression along different axes of power imposed by breaches of kāwanatanga, together with the protection of our rangatiratanga. So we need to be protected from bad kāwanatanga. Surely our tupuna signed the tiriti for good kāwanatanga, not mediocre, not bad. Surely it's great kāwanatanga we deserve. And not only that, but we deserve the protection of our rangatiratanga rights. So we need structural redress as well as the right to design our own solutions and the resources to make that happen. Mauri ora ki te whare.
Tēnā koe tuhine, ki te a koe. I've got a few things I just want to explore a bit with you. First of all, on the issue of comparability, it seems, I know what you're saying, we are, Wāhine Māori are ourselves and need not necessarily be compared to women, to Māori men, to other cohorts. But don't you think it's quite hard to escape doing that with the emphasis on equity in measuring outcomes? Like what's some of the alternatives to...
Those measurements are there. There's part of me that is concerned that if we, women live longer than men on average in a modern society. And part of me is concerned someone's going to say, oh, but what about Māori men? And I don't want that competition to happen because that's really not the issue in a comparative between men and women. I'm much more interested in the fact that I don't live as long as white men. I'm very interested that my female hormone that I've put up with for many years don't provide me with the luxury of living longer than men. In the racialised society that we live in, they provide me with, I live longer on average than a Māori man, but I want to live longer on average than a white man because I think that would mean it's a much more just society for me. Okay. So the comparators are all there, and we can do that, but for what purpose do we want to do that? We know there are inequities.
So in terms of the for what purpose, in your brief you talk about the purpose being for restoring balance. So how do you know when the scales are tipping back towards balance?
Okay. In part one of the Hauora claim, the finding was that in the 20 years of monitoring health outcomes for Māori, during the 20 years where equity was supposed to be part of the Health and Disability Services Act, very little changed. That was when it was supposed to be a focus. So I don't want us to be monitored to death. So how will we know when it changes? I think there's still a monitoring system in place. I think we still have challenges with data quality in the system. That's getting worse, possibly, but there's still a monitoring system in place. So I'm not denying there's not monitoring happening. I'm just denying that we should make an issue of it here when it's stagnant.
I just wanted to pick up a bit on your kōrero about the kāwanatanga sphere and the rangatira sphere. And particularly, I want to hear your views on what, if any, role you think the Crown has in the rangatira sphere.
Well, I was interested in the Te Aka Whaiora presentations, where the claimants, they actually claim Te Aka Whaiora as part of the rangatiratanga sphere, as an action space for rangatira, for tino rangatiratanga. In my analysis, it is actually an intervention the Crown put in place to try and fix the inequities that were continuing to be, that weren't being mitigated in any other way. So I thought it was an intervention in the kāwanatanga space. However, it did provide a space, I guess, where Māori providers were able to feel that they were able to operationalise their rangatiratanga. And I take it on board that that's a space that they felt safe in. So I'm just telling you what my view of the kāwanatanga space was. Yes, I think it was a great thing that they decided, the Crown decided, we're stuffing it up in terms of equity, we need to do something different, let's have te aka whai ora, let's have iwi Māori partnership boards, let's have a hauora Māori advisory committee. So they decided to make that a focus and put a new intervention in. Great. We didn't get a chance to see if it was going to work before it was disestablished.
So you, it sounds to me like you're saying actually these spheres don't operate in isolation of each other, and then that there is actually potential for them to intersect and provide that space where it's good for both spheres to be interacting together.
I'm not quite sure if I go that far.
Okay. Okay.
I'd have to think about that some more. And I'd have to, I'm not sure it would work for everyone.
Okay.
That some people would prefer a totally separate sphere. Because, you know, in He Pupu, well, in Mātiki Mai, the third sphere is the relational sphere. How do we do business? When do we have to do business together and how do we do it there? And that's an unexplored space.
Right. So that might be like less of an intersection and more of a this is where we have common interests.
And we have to do some work together, yeah.
Just one more area I wanted to ask about, and that's when you talk about resilience and, you know, that essentially, you know, Māori showing resilience is actually, you know, it's the excuse for the failed system. And it's the it's what it's the burden that comes onto Māori of that failed system. So what do you think we need to do about that? Like, you know, what do you think needs to happen within the system? Where would you focus so that Māori aren't needing to show resilience because the system continually fails them?
I don't have a problem with resilience. I have a problem with the fact that for people who can't become resilient, they become victims, and they often are damaged by the system that tries to make them fight against it, become resilient. And I think we need to get rid of the systems of oppression. I think isn't it? It's so wrong to say, oh, well, if you're strong enough, you're going to survive, and if you're not strong enough, too bad. We've got a prison place for you, or we've got, you know, a mental institution or diagnosis for you, or we've got a low-paid unemployment benefit for you. That's what we're saying. If you're not resilient, you're going to be a non-survivor. And I think that is a really bad policy choice, and it's a very difficult one when the scales are very unevenly sloped, not in our favour. So, yes, I honour the people who are resilient, but I also see people who haven't been resilient and the price they pay. So I do think we have to stop saying the systems that we have that create this imbalance are okay systems, just because some people end up resilient, if that makes sense. So we've got to stop the oppression. We've got to stop the racist systems. We've got to stop the misogyny. We've got to stop the paternalism. We've got to, we've got to change that.
Tēnā koe, Dr. Reid. A phrase we hear a lot in the news these days is access to services being determined by need, and that sort of has a surface logic, but I wondered whether you had a comment on that, especially when it comes to Wāhine health.
I'm reminded of the wise words of Dr. Moana Jackson, who said, needs exist when rights are not, are not permitted. So if we can prove, as we can easily, that Māori have higher needs, it's because our rights have been abused, our rights have been breached, including our treaty rights. So if we really want to get to the cause of sorting out needs, and especially disproportionate needs, then we really need to get to the source of where our rights have been breached.
All right, thank you. That's my only question.
Tuhiwai, Pātai?
I am on the hauora claim, so I just want to acknowledge all the mahi that's been done in that space. And I also heard your comments really about, and also earlier, Natalie's comments. It's not the Olympic Games of oppression, and racism and sexism intersect with each other. I guess I do have a question, because I think there are other data sets and statistics which actually do show that Māori women have a range of health needs, morbidities, comorbidities, that are particular to Māori women. And I was recently shocked by looking at suicide rates and the number of Māori women who basically are pregnant and commit suicide. You know, so it's like there's a lot of those sorts of things that exist for Māori women, right? That the statistics are shocking.
Ai pono marika. And I want to acknowledge Annette and her mihi atu ki Maria today. But you know, it's just as shocking if a young Māori boy dies by suicide as it is by a young Māori woman. Yes, it's shocking that a pregnant woman takes her life, but it's still all horrific. And I don't want to judge one loss against each other. It's enough to say that we have got horrific youth suicide rates that have got worse over the last few years. And yes, you know, mental health amongst rangatahi, yeah. But what we need is action and intervention. So yeah, there are, you know, the birth statistics, maternal mortality, the infant mortality, the neonatal mortality. These are all statistics we can talk about, but are we any closer to recognising that we've got a structural and systematic problem and we need to change it? And we need the government to stop pretending that we're going to look at equality instead of equity. I think those are a bit more important to me at this time and in this claim than listing our needs like that. I just, yeah, people's pain is real, you know. Our whānau's pain is real, yeah.
Yeah. Ngā mihi, thank you for that. No other questions, Judge.
Tēnā koe. Tēnā koe, Paparangi. Mihi ana ki a koe te tō mai te hauora ki roto i te whare. Dr. Reid, I'd like to, I'm not sure whether it's a question, but I'd like to hear from you as to what your take is on certain concept, maybe as in my head going around after listening to your kōrero. And that is, in the Justice Inquiry, quite often a statement that comes from people giving evidence is the system is designed exactly as it is supposed to work. And that's largely based on the set of data, the demographics, and that is based on a particular type of person in society who's the majority, and meeting the needs of that majority group of people is really what the system is set up for. That's the first part. The second part is recognising that because this has gone on for so long, a lot of our rangatahi in particular, and probably earlier generations, complete mistrust in the system, complete mistrust in what has been put forward to them, that then builds almost like a whole perspective of the world of what hauora is that is not reflective of the reality of what we've been faced with.
Not sure if I should thank you for that question. The first part is perhaps a little bit easier in terms of sometimes we forget to talk about it, but if you think about a coin, and I know we don't really do coins these days, but on one side of the coin there might be inequity, but on the other side of the coin is privilege. And we often, I think when I was working at Iru Pomare Centre, Bridget Robson did a whole report where she didn't talk about, oh, Māori have less, blah, blah, blah. She said, Pākehā have privileged, and she wrote a whole report on child health talking about Pākehā have privileged access to this, Pākehā have privileged outcomes. And it really was a really important thing in training our mind to think about, yes, the system is designed perfectly for those in our society who have privilege, and not for those who have inequity. Because that is this, the sifting off of somebody's privilege rights, somebody's equity rights into making one group privileged and another group less privileged or have less access to those rights. It would be easy to lose faith in the system, and I have to try my very hardest not to, because I help train people who say they want to work in the system and make a difference for Māori health. And that's a very important part of my job. And I believe in it. I believe that we have to change the face of the workforce. We have to change the way in which health care is delivered. And those are really big issues, especially at the moment when the health system is under so much stress. But I believe that we showed a lot of potential during COVID for how do we want our system of health, community health to run. And I think that we have shown that potential in other ways too. So, yep, we've got to change it. One healthcare worker at a time, one manager, healthcare manager at a time, one Māori health provider at a time, and we've got to build a parallel, a system that our people can trust. So I'm full of hope there, full of hope.
Yes, pai ki te whakapono, engari anō, we need action as well, ne? The last part, I was thinking, yeah, I'm not sure how.
It's going to be a hard one, isn't it?
No, well, I was, like, and you said you don't want for the focus to go on data gathering, when in actual fact it looks plainly obvious that there is heaps of data that says quite categorically that certain things should be done, but in the political environment it doesn't. There's a whole nother conversation taking place that isn't data driven at all. Have you thought about what sorts of interventions or what's going on there? Sorry, that's why I'm not sure how to frame it, because I've got some ideas around doing things and then getting data on what we're doing instead of what the system is, rather than gathering data of what the current system is providing.
So I wouldn't be surprised if for the first time in a long time our health gets worse over the next 5 years. And I'm happy for there to be good data systems in place that we will be able to monitor that. We mightn't be able to directly put a finger on the causal pathway, but if you make if you reduce unemployment benefits, if you make people low income, if you make services in a cost of living crisis, if you make more people unemployed, predominantly Māori, if there's no jobs for rangatahi, you are going to have all health outcomes going sideways or downwards. So we can see we're in a very dangerous landscape at the moment. We, at this stage, we can't change the politics. That's why I quoted those two things from the report. We know the limitations of the tribunal, but I'm really happy for the tribunal to point out to the Crown that they have responsibilities besides to their electorate or to their voters or to the people who want something from them. So that it might be that we're at a moment in time, tai timu tai pari, where we are stuck in this moment. I don't think that we'd be able to necessarily change people's mind, but we can keep dialogue going in the public arena, so we might be able to change some people's minds, but we really have to organise an electorate. We have to organise for and the next government, shall I say.
Nā koe ki era kōrero, just I'd really like to see sort of what are interventions for wahine Māori that have been effective and maybe haven't had support. That'd be really important for me to sort of understand this from a wahine Māori perspective.
I think a lot of the early work that I was involved in, like I was involved in early work on cervical screening, and yet there has been a cervical screening, a national cervical screening program, and it's changed, and big mihi to Bev, if she's here, for her work with HPV vaccine. However, you know, the mana of women like the Smear Your Mare campaign, all these activities, you know, when I was involved in Smoke Free, you know, the number of women who got involved in Smoke Free following those early initiatives that I was involved in, and then to have it undone by policies at the moment. So I think there's plenty of examples where when Māori women get busy, things happen, especially at the grassroots and community level. But it's not sustained, it's not, mainstream don't support it, it's still sidelined and still not, the rangatiratanga of those campaigns have not been adequately supported and allowed to flourish. Does that make sense?
No, tino pai rawa atu, ngā mihi ki a koe.
The change in emphasis that you have outlined to us from equity to equality, do you see that as primarily a philosophical, political push, or has there been any attempt to dress that up in evidence of any kind?
Not that I can see. It's the phrase, we should be treating everyone the same, but actually we don't treat everyone the same. People still have differential access to primary care. People can't afford access to primary care. People still have differential access to secondary care. People still have differential access to housing in the moment where we have, you know, child poverty. We still have differential access to income. So even though they want to say the word equality, we don't live in an equal society.
So, I mean, I've also been struck in those kinds of, in that kōrero around equality and versus equity, the lack of any acknowledgement of the dimension of indigeneity in that, in those statements and conversations?
I think that's because that would complicate the matter. I mean, the fact they don't get the difference between equality and equity, and that's, to me, simple enough. It's in the literature, nationally and internationally. It's in previous policy statements by the Crown, and yet, and we at this stage, we're keeping it away from te tiriti. It's there in the same policy statements, but even if we just, that level alone, they can't handle it. I'm pretty sure they couldn't handle treaty and equality. So I don't, tempting as it is to point out that there are already te riti obligations in their own policy statements, they don't welcome that conversation. So we're in a very interesting time when we can't have a mature conversation about the scientific literature and human and Indigenous rights.
Nā mihi ki a koe, nā mihi me o whakaro o tēnei ahiahi. Thank you very much for your evidence today. You've given us a lot to ponder.
Tēnā koe. Tēnā koutou katoa.
Well, tēnā tātou. That brings us neatly to the end of the program for the day. So I'm happy. Are there any matters that council want to raise at this stage?
Oh, kia ora, Judge.
Yeah.
Just two small matters. So firstly, I'd like to return to the point that was raised earlier about managing any apparent or otherwise conflicts of interest and how you intended to do that, acknowledging the connections that people in the panel have with people who have given, who are going to give evidence, and understanding that, Judge, you yourself have not assessed it as being something that's problematic. The Crown not having detail of those things isn't in a position to, say very much, but a pragmatic solution might be for the particular connections to just be noted in advance of the particular evidence being presented, whether that's by email or whether it's said. Just a pragmatic path forward. Yeah.
All right. Well, it's certainly not a matter of Dr. Smith bringing those matters to my attention late in the day. In fact, that was done last week, but I was just taken up with other matters in Te Kōti Whenua. So I am happy to put that into writing, maybe by email from the staff. And if there are any submissions that you want to make about that, if those could be done by, well, as soon as you can, by the end of the week at the latest. If there are any issues of concern for you. You have my view of it, obviously. These are matters which have been previously discussed at prior hearings. You know, my view of it is somewhat pragmatic in that the Māori world is a very connected world, and also because Dr. Smith, because of her expertise in these areas, that's why she is on this panel. So, happy with that kind of approach?
Yes, I think just getting a little bit more information as to the particular, we'll just,
Yep, that's on me, I think. Anybody else want to say anything about that? Okay. Any other matters?
Ma'am, can I seek leave to be on line tomorrow to brief witnesses, and Ms. Hira will be here.
Okay. Yes, I'm happy to grant that leave, Ms. Sykes. Okay. All right. Well, we will end the day.
Tēnā tātou. Nā tū tātou i whakarite ki te karakia i te timatanga o a tātou kōrero. Māku e whakakōpani tō tātou rā. Engari, ko te inoa i roto i au, e tuku atu ana ki a koutou ngā kai kōrero o te rā a pōpō. Mā koutou e whiriwhiri māwai te karakia. Kāre he aha ki au nei, ko te mea nui nei, ko te ahua o te karakia e whakaari atu ana i te wairua o ngā kōrero ka tukuna i roto i tēnei whare. Kare au i te awanga ki tērā. He mārama ana tātou ki te tikanga o te whare nui, no reira whakairihia ngā kōrero ki runga i te whare, ana kia pai te kawe o ngā kōrero i te roanga o te rangi. Ko te mea nei, i te ata nei, tai mai tātou i te, te hihi o te rā, ka ua, ka hau, engari anō, kei roto tātou i te ahurutanga o tēnei whare, o te tumu herenga waka, no reira ka whakairihia tēnei kōrero i runga i a tātou i tēnei wā. Pērā oki rā te uuka o te rangi, te tukutuku o te rangi, te ei o te rangi, te mamange o te rangi, e rongo purutia kia purutia kia mau. Purutia mai te tauri o te rangi, kia tīnā, kia oena, kia toko te manawaora. Tīnā toko te manawaora ki whea, tīnā toko te manawaora. I rangi nui e tūnei ki papatua nuku e takoto nei. Ki tēnā o tātou ngā whānau, ngā kai kreme, ngā roia o tira, te karauna, tātou katoa i noho nei ki raro i te maru o te tuanui e tū nei, tūturu whakamaua kia tīnā hui e. Tēnā tātou. Kia tau te pō.